से सभी। कोई लम्हा मेरा ना हो तेरे बिना, हर सांस पे नाम तेरा। क्योंकि तुम ही हो, अब तुम ही हो जिंदगी, अब तुम ही हो चैन भी मेरा दर्द। कोई लम्हा मेरा ना हो तेरे बिना, हर सांस पे नाम तेरा। क्योंकि तुम ही हो, अब तुम ही हो।
Short of the above discussion is as follows. As regards the pipelines which have been drawn, the applicants may approach the relevant district coastal zonal management authority within a period of 1 month from today. The district coastal zonal management authority will consider any application made in regard to the continued use of the pipeline and take a decision in accordance with law within a further period of 6 weeks from the date of the receipt of the application. Discussion in view of the request made by the applicants that regards the pipeline which will continue to use the pipeline along with the storage facility for a period of 1 year, we would think that the interests of justice do require grant of some time. Appellants are accordingly given a period of 6 months from today to comply with the implement order of the NGT. This is in regard to the direction to demolish the storage tank. The appellant in the first appeal is given a month's time to pay the compensation ordered if not already paid. As far as the direction to demolish the pipeline, the matter will await the decision to be taken by the District Zonal Management Authority. That means that partly allowed. There will be no authorized clause.
Obliged.
Yeah.
501.
You see, from what transpired yesterday, what Mr. Diwan was telling, there were attempts, earlier bills were placed, but it didn't work through. Today, of course, we have the Attorney General also, along with the Solicitor General. So, what he was saying is, there is many a slip between the cup and the lip. Just because a bill is proposed to be presented before the Parliament, it could go before a committee for deliberations. So, in near future, it may not be forthcoming. So, that is the anxiety expressed from the other side. And we take it that what Mr. Mehta told yesterday, the same is the stand of the Attorney General.
Yes,
if the Attorney General would apprise us of the timeline within which you reasonably expect that an act is coming into force, then there could be a reason for us to sort of say that, all right, we don't sort of proceed with the hearing, but otherwise, there's an element of uncertainty because you are asking for comments from the public and you are saying that you are proposing to present the bill. Now, what happens? We know timeline within which you expect own ways of going away.
That's how the consultation process will add
So that's
strength
why-
to the whole deliberations both in Parliament and outside. I suppose, therefore, what is one concern is that when the Parliament is likely to get into this job, will, for any reason, the court will kind of orient a parliamentary debate or a public consultation? May not. May not.
Because
That's one
see,
concern.
the hearing is happening not now.
Might have.
It was happening
Several-
I think sometime in September, perhaps, when such an assurance was forthcoming. Mr. Mehta was there, and but as yet we are at this
Lordship
stage
knows
of.
the deep dimensions of a debate like this.
We are not looking into their functioning.
Yeah.
The legislature would have its own way of functioning. But as a court, what are we
Your
doing?
Lordship's concern, my lord, is, my lord, I bow down to that, my lord. My instructions are specific, my lord. The Parliament session has started from yesterday. It's in 2 phases. The second phase would start from 13th of March. My instructions are that subject to the bill getting approval from the cabinet, my lord, it has to be routed through cabinet. It is intended to be presented in the second half of this session. My lord, that is between 13th of March to 6th of April. These are my instructions, and I have said so on affidavit also. There, my lord, we have not said the second half part. We say we intend to my lord, introduce, but I took instructions, my lord, day before. Yesterday also, my lord, I had a discussion with the Honorable Minister. He said we can't say what the cabinet will do, but subject to that route, we are ready and we would introduce it in the second half of this.
This is a short session, Manoj. There is only 1 week.
This is
So
for
that's
on
why
the budget, Manoj.
Yes, only for the president's address of the budget, Manoj, and thereafter.
Bills would necessarily
Be
come
in
in
the
the
next session.
next leg of this session.
Yes.
It can't be introduced in this session. That's it.
You see, Mr. Sibal has the experience of the other side as well. except,
No, my lords, your lordship is absolutely
no,
right.
so therefore,
I tell
we
you,
are saying that between the
no.
up and
My lords, the way even when the bill is introduced, my lords, in the second half of this session, my lords, it may go to the consultative committee or the standing committee, and that takes another 2-3 months. So that is there, my lords. That means it can stand over. Ultimately, it will become law definitely by July. This is my, if it doesn't go to the committee, my lords, it will become law immediately. If it goes, it will become law by July. That's the timeline, honestly, that I can give to your lordship. Nothing more than that.
And we, my lord, can't assure what would happen on the floor of the house.
That's right.
Whether it would be passed, it would be.
No, that
I mean,
majorities
I thought-
are there. We are all in support of
No, not it would be. I'm sorry, my lord, my learned
So
friend.
the bill itself,
My learned friend took it, my lord, purposefully wrongly. I didn't say it would not pass. It would pass, numerically, but it might be referred, etc.
That's what I said. I said that.
That's all.
That's what it is.
so
And,
from the experienced parliamentarian, we are getting a target of July.
Definitely.
So what Mr. Diwan is saying that, this timeline of next session of the parliament, how far that will have a repercussion, that's something we have to consider.
Whereas my request to your lordships is the following, Whereas even if your lordships were to actually hear the matter, we are not objecting to it. Even if your lordships were to hear the matter, what will happen? By the time the judgment comes, Whereas the bill will have either gone to the standing committee, then whereas your lordships or judgment or passed, your lordships judgment will stand in the way, Whereas, of the bill that has already been passed.
It might, the parliament may be benefited of the judicial view on this.
The problem
The
there,
parliament-
I'm sorry to say that the problem there is, I'm sorry.
Where
Normally, we wouldn't override, not normally.
No, I'm
We
saying
would
something
not
else.
override the parliament.
No, Malas, I'm saying something else. The problem there is that the nature of this legislation is such that it is not just an ordinary legislation. It has ramifications on investment. It has ramifications on freedom of speech. It has ramifications on privacy. It has ramifications on not just WhatsApp, because today the target is WhatsApp, but it will impact every other intermediary in the system. And that's why 9 distinguished judges of this court said, in matters of this nature, we should await Parliament to pass a legislation. And I will invite your lordship's attention.
That is a.
That's all that I'm
Of course.
Yes. No, therefore, mothers, what is going to happen between now and July, assuming that's the last date, it may pass in April, March itself. But assuming, mothers, it is between now and July, what's mothers? If at all, mothers. It took 6 years in the European Union to pass the bill. 6 years.
Maybe
one more thing,
maybe I was wrong in choice of my word that parliament will be benefited, but
Lord, one more thing.
yes.
Once Parliament passes a law, your lordship does sit in judicial review, and your lordship,
That's right.
Lord, obviously can. But your lordship's judicial review, your lordship's judicial pronouncement being debated in Parliament for acceptance or
That's
rejection
not right.
should always be avoided.
Yes.
Not that. Sometimes not laws are passed overriding any
Lord, the
decree order.
Well, if your lordship renders a judgment earlier, what will happen? It will be debated.
it could be debated, but Lord, and the
Lord, I would
purpose
not
is,
insist
Lord,
on
the
that.
purpose possibly, I'm not talking about the litigants, Lord, here.
We are not on all this
Lord,
debate. of
discuss the
parliament
bill
and-
and find out the inadequacies of the bill,
Yes.
criticize, etc.
We
It
would
should
go
be avoided.
into,
Manoj.
we
Why?
would go into discussion over the bill.
No, but
but the
necessarily,
issues
Malad,
issues
issues
will-
are exactly the same.
And
Issues
the
with-
irony is,
Privacy, consent, they're all the same.
my lord, irony is, as I said yesterday, I am supporting the users, namely Mr. Diwan and my lord, the side he represents. If the bill comes into effect, it is the intermediaries who will have to challenge it.
My learned seems to be very sure about that.
Your geographical position is not correct.
No, that's correct. Malad.
That's what I said.
We don't know, but that's a very good speculation.
Yes.
But quite frankly, Malad, I have not contradicted him even once. I personally know, Malad, that in fact, when the bill comes, it will support our position. That's what I think. Maybe my learned friend
Anyway, there's
hasn't.
nothing to challenge that.
We can't speculate.
Be that as it may. This is our submission, Malad.
May I just make a few points? in the nature of recapitulation, just one or two.
Bro, I just want to add one thing before he starts.
You are
I'm for Meta, bro. I'm for the main holding company. I just want to mention that there is no Vishaka situation. There are regulations in place now. Already regulations are there.
We said it yesterday.
There is a mechanism. There is an officer whom you can complain to. He have not made a single complaint to anybody, and they're challenging everything in the air. So it's not as if the people are helpless. This is a complete 2011 regulation with a complaint mechanism, grievance redressal officer. So it's not like Vishaka where the law is crying, it's a complete vacuum, or people's human rights are being trampled over.
But only one more addition, Manoj, before
Lordship,
Diwan.
just as we don't discuss sub judice, once it is before the legislature, what will happen is your Lordship judgment is Article 141, binding. Some legislature comes. Now, they should not be that your Lordship holds A plus B is equal to C, and then the Parliament says A plus B is equal to D in advance. That may lead to a slightly awkward position, if I may use a term.
Constitutionally awkward. Another aspect.
Just say one thing. These are discussions or debates in relation where there is no specific complaints we are dealing with. As I said, there is a 2011 regulation. That regulation is holding the field. Maybe adequate, maybe inadequate is one thing. But that's not a ground, to strike it out and then do what? The second one is on the anvil. The second one is on the anvil. The first one is not challenged. The statutory regulations are of 2011. They are not under challenge. These are, these are kind of allegations. If this happens, that happens. There's nothing concrete, really speaking.
Yes.
So that
One addition, Manoj, one addition.
nothing, specific. Unless there is something specific, if it has waited, for so much time, another 2 or 3 or 4 months can't really make a difference.
In fact, what the
And have this clash between the legislature, doing one way, court doing another way, just because 2, 3, 4 months are in the interregnum.
Not in fact the question
matter
that they
of 3, 4
framed.
months.
Sorry, sir. But in fact, the question that was framed by them for your lordship's consideration was whether the state should act to bring in a legislation or rules. Now that's what's happened. That's in fact the question framed, which is at page 778 and 7789 of the convenience compilation. That is what they wanted. Now there is a law. Now how can they now go beyond that?
Don't wait for the
One have a word in. I think he's really anxious.
certainly.
Only one addition, Manoj. In one of the matters, Manoj, the regulations are also in question. Now the new regime, which is yet to come, Manoj, takes a different view of the regulations.
Yes.
That
That
is
is
not, I must note the point.
That is also true.
Why don't you voluntarily undertake the intermediaries? What is coming?
They should, Manoj. They should.
Yes.
That's our case, Manoj. They should.
Manoj, yeah, we are not standing in the way, Manoj.
We are saying that you have your own code.
Yes, we are compliant.
Whatever
Is coming.
whatever you are doing in other countries,
Yes.
you cannot discriminate India. That's, Manoj, the stand of the.
Manoj, hold on. Manoj, that's what. There are two global regimes. Manoj.
Yes.
One is US.
One is the US and the rest of the world.
So Europe and rest of the world.
Yes.
That's what I'm saying.
Correct,
Then Europe. So Manoj, they are saying you follow the European regime. We are saying you follow the other regime. Now that's a matter that the law will decide.
What is the proposal?
Manoj, if
European regime of the-
not
Indian
the
regime, Manoj,
not the
which
European
protects
regime.
the privacy and Manoj,
Because
everything.
we have possibly have maximum number of subscribers.
600 million.
Yes.
600 million, Manoj.
No
Manoj,
intermediary can ignore India.
The proposed legislation considers both the European as well as the global
And then
regime.
takes a view.
And then takes a view.
Yeah.
Therefore, that
Our legislation should be the bellwether.
Yes, absolutely. Because
therefore-
we are serving 600 million people. It has to be. It should be.
Intermediaries, Manoj, cannot ignore Indian users.
Absolutely. No, we are not.
Commercially, they cannot ignore.
We will not. We will not. No
In fact,
question.
on behalf of Twitter, I'm appearing for Twitter minutes in one of the petitions. Our affidavit indicates how the proposed legislation takes care of the grievances. So there's no question of intermediaries necessarily being adversarial to this
Whatever
legislation.
is the proposed legislation,
Lordship, please.
are you complying voluntarily with the requirement.
It's under debate, Malad. How can this is public discussion?
Care of all this.
No, I can understand the central government's stand that Parliament is insisting over or is going to be insisting over the matter. But why are you kind of
We are complying with the law. Plus, there's a 2011 regulation. We are complying with it. We are complying with it.
That is under challenge.
But no.
In one petition.
In one petition, it's under challenge.
Otherwise, there is no challenge.
Otherwise, no challenge.
And there is no stay.
There is no stay.
Not the regulations are in force, they require a privacy
If
policy.
you
We
still
have that
want
in
to hear
place.
it, Malad, we
We're
don't
already
stand in the
under
way,
that.
quite frankly.
We are not going to.
Malad, we won't stand in the way still now. We have just put our points of view before your lordship. Beyond this, we will not.
Your lordships can consider, your lordship sees the anxiety of the private operators. The
No.
What is all this?
There's no anxiety.
Yes, steamboat, your lordship, we have saying that the 2021 policy, which will not collect large metadata, doesn't give an opt-out option, which they gave in the 2016 policy. Let them give us the opt-out option, to opt out of the fact that they will not share data.
WhatsApp.
They are all opting out of sharing the data. They want this situation, unregulated situation, to continue, so that they will not market the data. We have filed interim applications.
Does a proposed bill deal with that?
Yes,
Of course.
yes.
Of course.
It does.
It could be complaint.
Malad, in fact, the proposed bill says,
Sorry, the present regulations also
Give you
It deals with that.
it deals with it. Even the present regulations deal with it.
That's what I confess.
They deal with it. Malad, they say, if you do not consent, you can opt out of the system. That's what it says.
means is what? Just a moment. This will not go anywhere.
This
Let
is
us
what
see the present
Malad,
regulation.
quite frankly, please hear the matter, Malad. I don't want to.
Let us see the regulation.
Please hear the matter, Malad. We are not standing in the way at all. We are suggested, Malad, let's hear the matter.
See the regulation.
But I consciously said, when the bill comes, the intermediaries will challenge it. I said that conscious.
Please look at 72A of the Act. Your lordship will get the answer of the current legislation.
Where is the regulation? Let us just have a look.
Regulations, yes.
Sort of, how much of time is being taken in all this preliminary round that we don't get a.
This is your affidavit.
Now that Mr. Sibal and Mr. Tata, I both heard them say, let us proceed with the merits, let us proceed.
Yes,
with
if
the
you want to
merits.
proceed, Malad, I have
said to
we
proceed
have
with
no
the merits.
problem.
Let us proceed with the merits.
On behalf of Brother Ajay, I would like to flag a personal logistical issue. I just did a small little calculation. We have exactly 107 days till May 19th. So 18th of June, Ajay will pick off. Yeah, that's a logistic. It's been to the heart of the problem because when you hear it, it's going to.
Take time.
Not going to take all that much.
It's going to take a lot of time.
Lot of time.
No.
You say the anxiety that is being projected is not from the bar side, it's from the bench side.
We have not projected.
Don't make a comment on that.
We are aware of it, but we have not said anything.
And
It doesn't look nice for a lawyer to say that the bench will not be available. We never said.
your lordship's judgment would be quoted across all jurisdictions. So we will also assist your lordship's.
So let's have a look at this preliminary. Let's see the regulation.
Let's see 43A first, Malad.
This is the information technology. What are the?
Yes, the Information Technology Act 2000, Malad.
But see section
Section
43A
43A and then the
that's the
regulation.
power to make regulation and then
All right.
Mr. Sibal will show you the regulation. 43A.
43A. First.
Yes, we got it.
This itself came by an amendment.
Yes. Let's kindly see 43A was inserted by an Amendment Act of 2008 and came into effect on 27th of October 2009, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. For the purposes of this section, body corporate means, your lordships may leave that out. Reasonable security practices and procedures means security practices and procedures designed to protect such information from unauthorized access, damage, use, modification, disclosure, or impairment, or may be specified in an agreement between the parties, as may be specified in any law for the time being in force, and in absence of such agreement or any law, such reasonable security practices and procedures as may be prescribed by the central government in consultation with the professional bodies or associations it may deem fit. Sensitive personal data or information means such personal information as may be prescribed by the central government in consultation with such professional bodies or associates as it may deem fit. And then the penalty provisions. Then kindly come to 72A.
The act.
Yes. Capital 72, capital A. Save as otherwise provided in this act or any other law for the time being in force, any person, including an intermediary, who while providing services under the terms of lawful contract has secured access to any material containing personal information about another person with the intent to cause or knowing that he is likely to cause wrongful loss or wrong. My lord has that?
Yeah.
Or wrongful gain, discloses without consent of the person concerned or in breach of a lawful contract such material to any other person shall be punished with imprisonment for a term which may extend to 3 years, or with fine which may extend to 5 lakhs, or with both. Now, there is no proceeding pending in any court for violation of this. Now kindly see 75. And this is amended again in 2000 with effect from introduced in 2008. And it is in effect from 27th of October 2009. And there's no complaint so far from 2009 to 2023.
How is sensitive?
Now kindly, I'm sorry.
How is sensitive personal data?
Well, that's in the rules, in the rules. In the 2011 rules, it's there. But let's kindly now come to, I don't know whether your lordships have the same book at page 225.
Or 187.
Or 187, depending on which book your lordship has. It's the information technology, reasonable security practices and procedures and sensitive personal data or information rules 2011. And to say, that there is no regime in place, this is a Visakha-like situation, is completely wrong.
Very narrow definition.
1 second now. We are not on that. We are not on that.
The definition is
If the national is narrow, then the legislation will take care of it.
The court can't expand.
The court can't expand the definition and say that, look, it can only strike it down. Yes.
Mr. Sibal,
Yes.
I'd like to know this architecture of data information gathering. What all information do you have?
In fact, that's
to explain the parameters of the case.
Let us,
Well, this is the whole issue. This is a very complex situation. Your lordships may take it from me. Let me, state a basic fact. No personal message on WhatsApp can never be read by any person, including WhatsApp. Including WhatsApp.
what information would you?
Now, if a person is on WhatsApp and on Facebook, he has to be on both. And he is carrying on activities on Facebook. That information, like any other intermediary, will be known.
You would know how many times one has WhatsApp X or Y.
No. Even that is not. That's also not available. So it's a very, as I said.
So what is available?
We have a proper representation to your lordships for that on the merits of the case. We can give it to your lordships. But these are the issues that ultimately will be dealt with. The issues of privacy, the issues of consent. No personal information, medical information, your sexual orientation.
How do you segregate?
Because nobody can read. Nobody can read.
WhatsApp
can't read. Where's the question of segregation?
So WhatsApp, the entire data
Yes.
is
Not even stored by us.
Stored by you.
Yes, it's stored in the individual phone. Both the person who makes the call, sends the message, and the person who receives it, they have the key. Both have the key. We don't even have the key. That's why, Maharaj, there's been no complaint since 2009. We're in 2023.
Take Facebook. What do you access?
Maharaj, like any other intermediary, like Google, like Maharaj.
Like
That's
everything which was
that, Maharaj, even the government platforms the same, Maharaj. It is
what we are saying. Whatever one is looking at,
Yeah.
everything is being stored somewhere. Is that the
no, not Maharaj in WhatsApp messages, no.
not WhatsApp?
Yes.
Talking about
Well, that's known to everybody. If I am on Facebook and it's an open platform and I'm on Facebook, it'll be known to everybody. Maharaj. Supposing, Maharaj, I move from my house somewhere else and I use maps. Maharaj, the Google Maps, Maharaj, they will know from.
my phone reminds me that last month where all I have been.
So if your lordship moves from your house, Maharaj, to a guest, they will know that you have moved, Maharaj. That everybody will know. Maharaj, that's the nature of the. Maharaj, kindly see. This is the nature, the whole. Maharaj, this is a complete revolution that has taken place in the manner that we function. And we have, in Facebook, we have privacy policies, Maharaj, in place. And privacy settings in place. We can switch it off. We can switch it off.
We are still in the process of
Yeah, but so what I was trying to say to
deciding whether to hear
yeah,
the
what I was trying to say, Maharaj, your lordships may, I want to disabuse your lordships of the impression that whatever we say to each other in terms of messages or otherwise, even our conversations, is known to a third person, not even to WhatsApp. Otherwise, Maharaj, if this were so, immediately you would have got millions of complaints that look, these messages are being shown to other people from the platform. It is part of our privacy policy itself that you cannot use it. You can't. The question doesn't arise. We have filed affidavit to that effect. Maharaj, what is the information we have? Your EMI.
We have your
Phone number, name, which you give. That's all.
That is at the time of registration.
That's right. So that's the only information we have. It may not also be the correct name. Somebody may give a false name. Whatever name you give, that's the information we will have.
The phone number is
Only the phone number.
Basically, it's phone.
Basically, it's the phone number. There may be some other, but nothing to do with the content, nothing to do with personal information, nothing at all. And if you see, Maharaj, the rules itself, I will demonstrate to your lordships. Just kindly have a look at that rule.
So let us see the present rules.
Yes.
It's draft.
Yes, 2011.
That protects the right.
Yes, I hear it is. Maharaj. Well, the title is the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. My lords have that?
2E.
We'll read these. Act means the Information Technology Act 2000. My lords have that, those rules, all of your lordships?
Yeah.
Biometrics means technologies measure and analyze human body characteristics such as fingerprints, eye retinas, irises, voice patterns, facial patterns, hand measurements, DNA for authentication purposes. Body corporate, leave that out. Cyber incidents means any real or suspected adverse event in relation to, leave that out. Come straight, Maharaj, to personal information, that is I, Maharaj. Section 2, Rule 2I, small I. So rules define personal information means any information that relates to a natural person, which either directly or indirectly, in combination with other information available or likely to be available with the body corporate, is capable of identifying such person. All other words and expressions used and not defined in these rules but defined in this act shall have meanings respectively assigned to them in the act. Now, sensitive. So, there's a difference between personal information and sensitive personal information. Sensitive personal data or information of a person means such personal information which consists of information relating to password, financial information such as bank account or credit card or debit card or other payment instrument details, physical, psychological, sociological and mental health condition, sexual orientation, medical records and history, biometric information, any detail relating to the above clauses as provided to body corporate for providing service, and any of the information received under above clauses by body corporate for processing, stored, or processed under lawful contract or otherwise. Well, I just pause here for a minute. Since 2009, there has not been one complaint in India amongst the 600 million users who have said that any of this personal information has been revealed to anybody or is known to anybody. And WhatsApp does not process personal sensitive information, does not process. That's our policy. Then kindly come to Mullat's 5, Rule 5. 4, Mullat, 4. Body corporate to provide policy for privacy and disclosure of information. So we have a privacy policy. That itself is under challenge.
The investigating officer requests you for sharing the information.
Yes.
And are you bound to share?
The court gives an order, we share it. But only whatever we have, because what the content we still don't have. So we can't share that. That applies to WhatsApp.
Both are different aspects. They're sharing or they're bound to share. Both are different aspects.
What sharing or bound to share means what? We are now, Mullah, telling your lordships that we do not access any information. So where's the question of sharing it? So if there is a court order saying whatever information you have, you share, we share.
I don't know whether we'll end up discussing the bill, but just to understand it, if you come to 7 of what you call a clause.
Yeah, that's right.
That's right.
5-7.
That's right. 5-7.
Information.
Yes.
Very important.
Correct.
Can you read that?
Yes, 7. Well, it's body corporate or any person on its behalf shall, prior to the collection of information, including sensitive personal data or information, provide an option to the provider of the information to not to provide the data or information sought to be collected. The provider of information shall at any time, while availing the services or otherwise, also have an option to withdraw its consent given earlier to the body corporate. Such withdrawal of the consent shall be sent in writing to the body corporate. In the case of provider of information not providing or later on withdrawing his consent, the body corporate shall have the option not to provide goods or services for which the said information was sought. So he can walk away.
No. Either.
Correct.
No problem.
Yes.
The latter part of the last part of that clause.
Yes.
It permits.
Yes.
Contract it is entered into with somebody else, irrespective of consent forthcoming.
But that's the privacy policy to which they have already consented. Then only it happens.
No, you come to the extant rule. The provision is there already. It's actually a reproduction of already the existing rules in the form of a parent act.
Yes.
You'll find that as Rule 6 of the 2011 rules.
Yes.
These rules.
Body corporate or any person on his behalf shall permit the providers of information as and when requested to review the information they had provided.
Can you read?
Rule 6.
Next
rule.
No, we are asking you to read the rule, not the. We were actually on the act, the proposed bill.
Well, my lord asked me to look at the rules.
We are asking you, okay, you are reading the rule.
I'm reading the rule only.
So Rule 6 you are reading.
Yes.
See 5-7 of the rules.
5-7 of the rules is what I was
Existing.
Existing rule.
The same thing is there in section 7 is what we are pointing out.
All right. Let's to section 7.
Slightly
I just come there, Malad.
Proposed.
That's exactly the point. This is our case, Malad. The proposed bill deals with this issue.
No. See how it deals with it.
But Malad, that's for public discussion. That's for.
All right. What you're saying is just read the last portion if you don't mind.
Of the proposed.
I was Malad.
See section 7 as it is.
I'll do that. Consent of data principle means any freely.
Are you reading 7?
7 consent. I'm looking at consent.
We are on transfer of information.
Okay, I'll see that.
Please read that.
I'll see it then.
It's a transfer of information in the 2011 rules.
No, my lord is asking the
Proposed.
My lord is asking the proposed.
You don't know what
bill.
7 is consent.
Yes,
Here are 7.
Yes.
I was reading 7.
Not this.
Ah.
From this.
I'll
7
read,
of this.
I'll read 7 of this.
It's consent.
Consent. That's consent, Malad. That's consent. I was reading the.
The affidavit is reading. Yes.
What are you reading the rules?
But Lordship reading statutory rules, or are you reading the?
No, the statute, the present proposed seven.
So that is consent.
That is consent, Malad.
No.
If your Lordship gives me the page number, Malad.
Sorry.
You give me the page number.
Not propose.
The mistake is mine. Actually, I was reading from 2011.
That's right. That's what I was thinking. Malad. I was reading that myself.
34.
The book belongs.
He's referring to the proposed one now, which comes at page 34.
34.
Okay, yes, yes.
34, Malad. Yes. This is the proposed,
Always
Malad.
the convenience compilation.
Discuss seven.
But by passage of time when we start.
The 7 here deals with consent. That's right.
That's right.
That's why we were saying, Malad, these issues are being dealt with.
But then, which is a provision that deals with transfer of information?
17. Transfer of personal data outside India. That's outside India. Now, Malad, all. That's, yes, 17.
Does it deal with?
17.
Now we've done the proof. What is it? You have to clarify what.
Reading the proposed, please. It's no proposed.
17 is transfer of personal data outside India.
What about within India?
Within India, as I said, Malad, that we have all now data under the law has to be kept here. Whatever we have.
If that is so.
Yes.
The Rule 6, which is currently governing, will continue to govern. Let's take it that you bring the act, but you don't deal with that situation. Dealing with transfer of.
There is no rule.
India. And if you read Rule 6, which again I am inviting your attention to.
This says notice, Malad. That's what Rule 6 is here, body corporate. You are talking about the 2011 rules.
That's right.
Right.
So that will, if you read that.
I'm reading it. Rule 5, subclause 6 is what my lord is reading. Body corporate or any person on its behalf shall permit the providers of information as and when requested by them to review the information they had provided and ensure that any personal information or sensitive personal data or information found to be inaccurate or deficient shall be corrected or amended. There's no problem.
So it says the transfer of information may be allowed only if it is necessary for the performance of the.
Oh, your lordship is reading not 5-7 but 7 itself.
7 itself.
Okay. A body corporate.
For assistance. But your lordships are reading the rules from the point of view of WhatsApp, which is one of the intermediaries. The bill, the existing rules, etc., deal with large number of intermediaries.
That's right.
With which many of us are not even aware of.
What you're saying is,
all comprehensive.
What you're saying is, you read 7, which is the provision with which we are dealing with as of today.
7.
What does it really say?
A body corporate or any person on its behalf may transfer sensitive personal data or information, including any information, to any other body corporate or a person in India or located in any other country that ensures the same level of data protection that it adhered to by the body corporate as provided for under these rules.
Next sentence.
The transfer may be allowed only if it is necessary for the performance of the lawful contract between the body corporate or any person on its behalf and provider of information, or where such person has consented to data transfer. Yes, we are following this.
That's really perhaps could be the problem, because if you read the previous provision relating to disclosure of information which is contained in Rule 6.
Yes.
Please read that.
Yes, body corporate. Rule 6. Disclosure of sensitive personal data or information by body corporate to any third party shall require prior permission from the provider of such information who has provided such information under lawful contract or otherwise, unless such disclosure has been agreed to in the contract between the body corporate and provider of information, or when the disclosure is necessary for compliance of a legal obligation. It is for sensitive. It is only for sensitive information.
What you're saying is.
And we don't process sensitive personal data.
What you're saying is.
Yes.
A distinction appears to be made between disclosure of information and transfer of information. 6 deals with disclosure of information. Requires a consent.
Yes.
When it comes to transfer of information, now, for example, like you said, Facebook and somebody is on both. You make use of the information for purpose of various.
Not personal information, brother.
This is
Not sensitive personal information. No.
any information.
No, 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 no.
Rule 7 makes it very clear.
No, brother. With respect, it says transfer sensitive personal information.
That's right.
So it's we don't do it, but we don't keep it.
They're telling you, please read the transfer may be allowed only if it is necessary.
But that is by contract or consent, brother.
If it is by contract with a third party,
Yeah.
without the consent.
It is with consent. It can't be without consent.
But then what does Rule 7 say? Or
Either or, Malad. Malad, supposing I want to perform an operation, Malad, a kidney operation somewhere.
you want to perform your contractual obligation with
Malad, there's a kidney operation that doctor wants to perform, Malad.
giving perhaps the wrong example. We are giving an example where you have a pecuniary interest to secure in the sense that you have a financial obligation, then you are providing this information and you're getting consideration.
No, we don't. We don't, Malad. Your lordship may take it, record my statement. We don't provide that information to anybody.
What is there? That's your statement.
But Malad, somebody is challenging it. I'm sorry to intervene.
We are telling you the Rule 7 is capable of being utilized transfer information without consent.
We are in a constitution bench, Malad. If we are in a constitution bench, if any such infraction had taken place, it would be before you. They would have said that this is what has happened. We take consent every time. We don't do it without consent.
The question is not whether you do it without consent or without consent. The question is whether law permits you to do it.
But Malad, law does permit me as long as I have consent.
No, without consent you can. We are again asking.
But there's a contract then, Malad. Then there's a contract.
So if there is a contract, irrespective of the consent of the data provider, I mean the person whose data you are actually going to transfer, you can transfer it.
But Malad, if there is a contract, that means inherent in the contract is the consent, Malad.
It be part of, the sort of small print.
That's what I'm saying. It is inherent.
Small print that you will have, that you will actually.
No, Malad, there is no such thing.
For your lordship, is the nature of the consent. And whether
Malad, just kindly see 5.1. Malad, we are now going into the merits. Kindly see 5.1. Let me, Malad, just point that out. 5.1 says body corporate or any person on its behalf shall obtain consent in writing.
What's your...
Malad, may I just point out one thing? But let's do your lordships. If your lordships don't mind. Your lordships asked me the question. Kindly look at 5.1. Yes. I'm sorry, Malad. I'm sorry.
Okay. See, because WhatsApp may be in a different position.
Malad, they are only interested in WhatsApp. They are not interested in anybody else. This is only against WhatsApp.
The maximum user is WhatsApp.
Meta is there.
That's Meta is Facebook, Malad. They have not challenged Facebook.
They challenge only
WhatsApp.
Can I
But
give
anyway.
another illustration of how it operates? While maintaining that they must not share. But there are, my lord, for example, forget WhatsApp for the time being to understand, my lord, this rule. But there are several intermediaries. One of them is, say, Google Pay or Paytm. Correct, my lord? We use it. In some corporations or some companies, there is a contract with the company and the employer as a part of their cost, that the company would be permitting you to use your Google Pay up to the extent of, say, 5,000 for the purpose of buying groceries. Now, there would be a contract between Google Pay, that is the intermediary, that company which is reimbursing, and the user who is using the Google Pay up to 5,000. And that company would require that you provide us the information that he has in fact used it for grocery. That's kind of a contract is contemplated. But without consent of the user, no intermediary should or can transfer, share, or any way disseminate any personal or sensitive data at all.
We support him. It's exactly that. Kindly come to 5-1. We agree.
About Rule 7, which we pointed out.
I just point out consent, Malas 5. It says so. Without consent, it can't be done.
It says contract.
Kindly see collection of information. Body corporate to person on its behalf shall obtain consent in writing through letter or fax or email from the provider of sensitive personal data or information regarding purpose of usage before collection of such information. So consent is necessary. It's at the heart of the matter.
So your normal privacy policy,
Yes.
which we
Yes.
key in,
Yes.
do they contain this kind of data sharing?
Yes, 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 very much so.
100.
Very much so.
The 3 links are clicked.
This is the point I was making, Malaj, and this
Basically,
very
when somebody has clicked in
Yes.
without reading, because
yes.
Yes.
the print is
No, Malaj.
designed to
There's no
balance
question
the-
without consent. It doesn't have.
But if you download WhatsApp,
yes.
the first thing you have to do is to agree to the privacy policy by clicking. You can read it. It's not like that fine print of the dry cleaner without their old English cases.
How many pages are there?
Hardly.
And
But it's
Malaj,
not that much. You can read it. And it is not small print. You can enlarge it.
The pages.
Malaj, and this is true of it is true of every app. It's not just for WhatsApp, Malaj. This is
You
true
have
of
to
every
agree.
app.
The manner in which
You have
this
to agree.
consent is
So,
put is an
Malaj,
issue
point
to
is that is the subject matter of the legislation.
Now, without signing the privacy policy,
Yeah.
can I have access to WhatsApp?
No.
So therefore, my lord,
So essentially, with the user, there's an inbuilt contract
yes.
of sharing of information.
Yes, absolutely. No, what information? Malaj, kindly see. Personal information is not shared. Sensitive personal information is not shared. No way. Because we don't collect it. Messages we can't see, so that's not an issue.
So what do you collect as WhatsApp?
Malaj,
Available to you.
as I said, information, phone number, essentially a phone number.
Essentially, who I have contacted.
Yes, exactly. That also we don't know, Malaj.
See, my lord.
Then what do you know?
Only know, Malaj, if the enforcement authorities ask about a particular individual, we'll give him 2 or 3 basic things. What is called basic information. Basic subscriber information.
That is who is from whose phone it is being.
That's all. That we'll get. That's all. Nothing more than it.
When your lordship
The
examines
name and the
that
phone.
policy,
So, Malaj, the point that I'm making to your lordships is, these are issues that will be resolved in the law that is being framed. There's a chapter called consent. There's a whole chapter on consent. There's a separate chapter on consent.
In European Union,
Yes.
also is it implicit that you share this information? 1 minute. Do you have the same contract for European Union?
Malaj, that's a different regime. Malaj.
No, we are asking.
No, it's a different contract. Malaj, a different regime.
And in the United States?
Malaj, that's entirely, Malaj, same as in India. Same as in India. And the rest of the world, same as in India. Now the government is taking a call, Malaj, looking at both regimes and deciding what regime or the mixture of those. It must be an Indian, Malaj, flavor to all this. That's what the explanation is.
no, on the lighter side, it was said that whenever we click I agree on any of these intermediaries button, it is with the same application of mind with which we say I agree to our wives.
I don't know.
You don't have a choice.
I
You say I agree.
I mean, I don't know. I don't understand the flavor of that consent, Malaj.
This is on the lighter side, not on the
all.
lighter.
Later caveat is not applicable to the earlier one.
And there is no opting out in
I
that.
hope
Malaj.
it's not an official stand, my lord of the government.
No. This is not an official.
Malaj, may I tell you, Lordships, another thing? Forget WhatsApp. In many other platforms, Malaj, including government of India platforms, there is not even a provision which says I agree.
Yes.
Not a provision which even says ask for agreement. Continued use is deemed consent on government apps.
Yes.
Forget about WhatsApp.
Government apps mean which apps?
My lord, IRCTC.
IRCTC.
The ticket booking.
Yes, everything.
Arogya se.
Arogya.
Then my lord, Beam.
Any-
The payment app.
There is no reference to consent
At all.
So your lordships are now, if your lordships make this kind of law, all of this will be out of business.
They will be out of business.
We will still be in business.
By Parliament.
But all I'm saying is if you enter into this field, then all these issues will be, and that's exactly what the legislation is going to deal with.
Lord, may I put it another way? Kindly ask them what is that personal information which is shared of which they are aggrieved of?
That's all.
We must understand that, we are debating
I'd
it.
like to put to you something different. Kindly come to the rule defining personal information.
Yes, we'll come to that.
Section 2I.
Yes, I'm coming to that.
I.
Means any information
Correct.
that relates to a natural person, which either directly or indirectly, in combination with other information, available or likely to be available with the body corporate, is capable of identifying such persons.
Now you read the specific definition of sensitive personal data or information in 3.
In 3, physical,
No. Sensitive personal data or
yes,
information.
yes, sensitive personal data or information.
Kindly read that.
Yes, sensitive personal data or information of a person means such personal information which consists of information relating to password.
Password.
Yes. Financial information such as bank account or credit card or debit card or other payment instrument details.
Physical.
Then physical, physiological and mental health condition, sexual orientation, medical records and history, biometric information, any detail relating to the above clauses as provided to body corporate for providing service,
Correct.
and any of the information received under above clauses by body corporate for processing, stored or processed under lawful contract or otherwise.
Can we maintain a distinction between personal
And
information-
sensitive personal, correct?
Now, what is the subject matter of Rule 6? Now you will see.
Yeah. Only sensitive, Malak.
Only sensitive.
Yes.
Equally 7.
Yes.
That also deals with
Only sensitive.
personal data.
Yes, yes.
So can there any prohibition from your
Seven say-
Five.
personal information?
Yes, 5, Malak, 5.
Let us see.
Yes, 5, that's what I was
That's right.
going to you along. Yeah, body corporate or any person in its behalf shall obtain consent in writing through letter or fax or email from the provider of the sensitive personal data or information regarding purpose of usage before collection.
That is an expression which is defined, that's the subject matter of Rule 3.
Malak, now
That is not the same
C7.
as personal
No, 7 also talks of any other information.
Let us see.
Yes, C7.
So 5, 6.
7, you lodges me C7.
Yeah.
A body corporate or any person in its behalf may transfer sensitive personal data or information, including any information that includes personal information. So it is covered, and I can't collect it till I get consent.
So what about disclosure of information under Rule 6?
Disclosure to whom, Malak? It's only under a contract or consent after consent.
You know what you're saying.
Malak, it says pursuant to contract or consent.
See, there's a distinction between, as you saw, between personal information and sensitive.
And correct.
Number one. The Rule 6 only deals with personal, sensitive personal data or information.
Yes.
It doesn't deal with personal information.
Yes.
So if you disclose information as distinct from transferring information under Rule 7,
Yes.
will it be hit by the embargo in Rule 6?
No.
So then
No.
what is the guarantee that you will not disclose?
I don't collect that information. How will I disclose it?
It's personal information.
I don't collect it unless without personal with consent. Otherwise, I don't collect.
Supposing I send a WhatsApp, which tends to indicate my musical inclination, that I am interested in a particular, I'm listening to a particular singer all the time. Correct?
Correct.
So this information can be made available to somebody who would be
No.
selling that particular.
No.
What you're saying?
WhatsApp doesn't collect it.
Rule 6 doesn't prevent you from dealing with it. For the reason that Rule 6 has as its subject matter only what is contained in Rule 3, which is personal and sensitive information, not personal information.
No, it says personal, Wallace.
Because it sensitive personal data or information
No,
is confined. It is a subset of information.
Just read, Balad, it says personal information.
It is sensitive and personal. For example, they
Providing
have
certain or information. It says so 6, Malad. 6. It says sensitive personal or information.
It says the disclosure of sensitive personal data
Or information.
That is exactly what you now come back to Rule 3. It doesn't. That relates to medical. This.
It doesn't say or, Malad. Rule 3 doesn't say or. It says sensitive data or information.
So that is defined as exhaustively as contained in these, all these.
Yeah.
But what you're saying is personal information is the largest set.
Yes.
The sensitive information is a
It's,
small
I agree.
subset within it.
Yes, yes.
What is contained outside of the smaller set and part of the larger set cannot be made the subject matter of the prohibition in Rule 6 is all that we are saying. We don't know whether what we said. I'm not particularly tech savvy, except that I can operate it.
Disclosure of sensitive personal data or information by a body corporate
That is taken
shall
out of
require
Rule 3.
permission.
That is the Rule 3.
Yeah.
That is part of Rule 3.
Yeah.
That is distinct from personal information. See, data and information are two different things.
Well, personal data and information are two different things. Your Lordship is right, precisely what I'm saying, Mulad. And Mulad, we have to take, at the time of collection, we have to take consent.
Kindly come to Rule 3, if you don't mind.
Yes.
Sensitive personal data or information.
Yes.
It is defined as meaning A, B, C, D.
Yes, yes.
Like, and very sensitive, like medical condition.
Yes, but that question.
Or your, financial information.
Yeah, that's right.
There might be personal information with the meaning of Section 2, subsection I.
That's correct.
Which may actually be the subject matter of my right to privacy.
Read 11.4, Mulad. 5. Kindly see Rule 4. Kindly see Rule 4.
Rule 4.
Yes. The body corporate or any person who on behalf of body corporate collects, receives, possesses, stores, deals or handles information. I'm sorry. Was you about that?
Yes.
The body corporate or any person who on behalf of body corporate collects, receives, possesses, stores, deals or handles information of provider of information shall provide a privacy policy.
Correct.
For handling or dealing in personal information, including sensitive personal data or information, and ensure that the same are available for view for such providers by such providers of information who has provided such information under lawful contract. Such policy shall be published on the website of the body corporate or any person on its behalf and shall provide for item 4, disclosure of information, including sensitive personal data or information as provided in Rule 6.
Therefore, it is included.
Therefore, it is included. It is included.
Disclosure is included.
Disclosure is included, Mulad.
Everything.
And everything, Mulad.
Purpose.
Disclosure, clear and easily accessible statements of practices, type of personal or sensitive personal data or information collected under Rule 3, purpose of collection and usage of such information, disclosure of information including sensitive personal data or information as provided in Rule 6. Everything is covered. And then come to 5.3, Mulad. While collecting information directly from the person concerned, the body corporate or any person on its behalf shall take such steps as are in the circumstances reasonable to ensure that the person concerned is having the knowledge of the fact that the information is being collected, purpose for which the information is being collected, the intended recipients of the information, and name and address of the agency that is collecting the information and the agency that will retain information. I have to disclose it.
So your privacy policy must be disclosed.
Yes. No. Information has to be disclosed. What I am collecting has to be disclosed.
In the privacy.
In the privacy policy. Exactly what we have done.
So
the point that I'm sorry.
One thing is missing. If you come to this paperwork given to us, page 5.
That paperwork.
Let us go to the definition clause.
Mighty affidavit.
Mighty affidavit. I don't know what your Lordship.
2011 rules given to us in this compilation.
I don't have it, Mulad.
I think
that affidavit of
the government, Mr. Shah has provided to us.
Okay. Page, if your Lordship gives me the page.
current affidavit.
This one, that affidavit.
Okay. Yes.
Page 5 there.
Page 5. I'll just see page 5.
Come to
Yes.
this 2F is the information. Correct?
2F information means information as defined in clause Roman small 5 of 1 of section 2.
Now come to personal information. I.
Personal information means any information that relates to a natural person, which either directly or indirectly in combination with others available or likely to be available to the body is capable of identifying such.
Now we come to 3. Sensitive personal data or information.
Yes, that's a subset of information. Correct.
Now if you come to 7.
7. Yes.
We talk about sensitive personal data or information.
Yes.
That is in terms of 3.
No, that's transfer of information. That's
including any information.
Your Lordship is reading 5 or 7?
7, page 9.
Page 9. Yes, yes. Transfer of information.
Sensitive personal data or information.
Yes,
Including any information.
yes.
Now our question to you is this including any information? Including any information.
Yes.
Covers
Personal information.
from where you get it?
Personal information.
From where you get it?
So the information.
Because the information before I collect, Mother, section 5 says, when I collect the information, it can be both personal and other information. And I have to now seek his consent for that. That's 5.1, Rule 5. It says so. Definition, Mother, of information includes data, message, text, images, sound, voice, codes, computer programs, software, databases, microfilm or computer generated microfilm. It's all there, Mother.
Information, then personal information.
Well, it's first information, then personal information, then sensitive personal information.
So,
And all matters which
and the results.
correct.
Majority are concerned with personal information, not with sensitive.
Correct. So, matters personal information, as I have said under 5.1, restriction is higher, matters, therefore I need consent. And that 5.1 says so. Collection of information, 5.1 says. Well, it's the point that I'm making.
Says disclosure.
And then we have to disclose it.
Doesn't deal with it. You're not right. You read the schema 4, 5, 6. You find that what 4 contemplates is a publication of the privacy policy.
Yes. Yes.
That should be made available. What you are going to do with it?
It is available, Manas.
It's available. No
Yes.
difference.
Yes.
When it comes to 6, it is only dealing with disclosure of sensitive personal data or information by the body corporate.
Yes.
It does not deal with personal information.
Correct.
It's very clear.
6 deals with personal information.
It deals with sensitive personal data.
Correct. So, or information means.
No. That is because it is covered by Rule 3.
Okay.
Rule 3, you have to read it together.
Yes.
It says sensitive.
But 5.3 covers it, Mother. Even 5.3 covers it.
5.3.
While collecting information directly from the person concerned. This is information, but it's not sensitive personal information.
No.
While collecting.
Kindly read again.
While collecting information directly from the person concerned, the body corporate or any person on its behalf shall take such steps as are in the circumstances reasonable to ensure that the person concerned is having the knowledge of the fact that the information is being collected, purpose for which the information is being collected.
If you read 5.3 in isolation, you will not get the correct picture. You have to read 5.1.
I'm reading it. Body corporate of any person or a body corporate or any person in its behalf shall obtain consent in writing through letter of fax or email from the provider of the sensitive personal data or information.
That's again relatable to Rule 3.
Malas, or information relates. Malas, kindly.
Personal information.
Malas, I don't think I've been able to explain myself. Information is defined separately under the Act.
That's right.
Information, Malas, is the genus.
That's right.
Right? Personal information and sensitive personal information are species.
Sensitive
So when
personal data or information.
correct is species. Now, when the word information is used in 5.1, it is in the context of the definition of information. It is not sensitive. Read 43A now.
Clear. Kindly bear with me if I just read it out for you. Body corporate, I'm reading out Rule 5. Body corporate or any person on his behalf shall obtain consent in writing to etc. from the provider of sensitive personal data or information. Just for a moment, pause and go back to Rule 3.
Yes.
That says sensitive personal data or information.
Yes.
Correct?
Yes.
Now, wherever they wanted to refer to both the sensitive personal data or information and personal information,
Yes.
they've done that. Like instance in point is Rule 4.
Yes.
Correct?
Yes.
When it comes to collection of information with the meaning of Rule 5, though it is, as usual, the subtitle is misleading, it says information, it is limited only to sensitive personal data or information in 5.1. Now, thereafter, whatever is mentioned, it really is follow upon what is mentioned in 5.1. And then when you come to, therefore, 5.3, When collecting information directly, it cannot be understood as meaning referring to something not there in the.
Well, let's see, read the parent section 43A, Malad, that gives your lordship the.
Exactly, that is the point.
That's the point. Just read 43A, Malad. It talks of information.
What they, because this is subordinate legislation, what they have done is, they have, very carefully, they have made a distinction between sensitive personal data or information and personal information, that you saw disclosure, being a subset of the latter, and they have confined the use of sensitive personal data in Rule 5, in Rule 6, and Rule 7 only to sensitive personal data or information. In other words,
No, Malad, with respect.
Information which is a larger set, which is perhaps considered to be less harmful from the point of view of the right of privacy.
Yeah. No, with respect, no, Malad, and that's not how we have viewed it as WhatsApp, and that's not how we use it.
That's what now the petitioner is also.
No, Malad, that's not how we have interpreted it, and we are including that and that.
Are we sort of canvassing for?
Malad, kindly look at 72 now.
Are we saying something which is contrary to what they have?
Let me just.
They will not support us on that.
Do you have?
Malad, just look at 72 first. Look at 72A first. Just 1 second.
72A.
72A.
Section.
Yes, section.
72A.
Yes.
Yeah.
Now it says punishment for disclosure of information, not personal sensitive information. Right? Save as otherwise provided in this act or any other law for the time being enforced, any person, including any intermediary, who, with me includes us, while providing services under the terms of a lawful contract, has secured access to any material containing personal information, not sensitive,
That's right.
about any person, with the intent or cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person concerned, or in breach of a lawful contract. Yes, correct. Or such material to any other person shall be punished with imprisonment for a term of 3 years. So it covers.
Therefore, how it works would perhaps, my understanding may be wrong. When you sign up in WhatsApp, like you said, there's this thing, I just, but not the formal thing.
Yes.
So I agree to all the terms.
Yes.
One of the terms would be that I would have no problem in my personal information being made available in terms pursuance of a contract which WhatsApp has with some other corporate body.
Yes.
Correct.
I have to have a contract with the user, but be that as it may. Let's sort of leave that out. But have to have a contract with the user, there's not some other body.
That's right.
I can't with some other body have a contract and give his information to that body. That can't be.
What they have. Precisely what they have.
What's the point of laughing? We are trying to go into the issue and we will argue it fully as and when the matter starts. That's not an issue. We will show to you. Whereas what I'm trying to tell your lordships is, where are we going?
Take my, for example, my political views. Give you an example.
WhatsApp doesn't look at it even.
No. I'm not saying that you look at it. We are not attributing anything against you. We are just having this.
Well, the whole litigation is against me, brother.
My political views. The political views are not treated as sensitive personal data or information.
Well, I will not be acting for WhatsApp unless they know my political views. I will not be here.
But we are only pointing out.
No, it's a lighter vein.
That's right. That should be right. What you're trying to point out is categories of sensitive personal data or information you find in Rule 3, you don't perhaps find your political alignment as one of the sensitive.
That's personal information, not sensitive personal information. Yes. You're right.
So that cannot be the subject matter of the prohibition contained in Rule 6 or Rule 7.
72A.
But 72A, yes.
72A is different.
But that's the Marin statute.
There we are going to tell you, as we understand, it is either consent or subject matter of agreement.
Contract, yes.
Contract.
Yes.
So all of it boils down to the smallest of print, which we don't have now in this, because it's an electronic kind of thing, online. So you don't just see it.
It's a more
the substance of it, that all this information, which is personal information, not sensitive information, it can be passed on to somebody who would be interested in knowing if for commercial purposes, for their political purposes, it can be used. We are just contemplating that it's possible.
Correct. Malad, the problem with that is, if that is the law, Malad, that there may be a small print, or you may not have understood it, or some people are uneducated, they don't read it. If that's the case, Malad, all intermediaries must stop business in India. And Government of India, all apps in Government of India must stop. That's the consequence.
Sensitive personal information. Even every.
Malad, in fact, they carry sensitive personal information.
My views about a particular
Including password.
My views about a particular politician. I'll give an example.
Yeah.
My views about a particular politician.
Yes.
Now, if the views are, sort of gathered by you and passed on to somebody else, you may take a choice to feel that person as a candidate. You may say that it's better not put up that man as a candidate.
Well, all I can say is this doesn't apply to WhatsApp. It may apply to other intermediaries, it doesn't apply to WhatsApp.
Only one.
That's all I can say.
These are 2011 rules.
If you go in
File assessment may not disown the responsibility.
May I add one word, Malak, to this? I'm for Google, Malak, not WhatsApp. This is a question which fell from.
You are a repository of all information.
Yes, and therefore, Malak, I'll answer this. What troubled my Lord Justice Joseph is this: that let's say Sergeant Puvaya, my information, Malak, which is not personal sensitive data, SPDI, sensitive personal data or information is one basket. Now, my medical condition is SPDI.
Absolutely.
Therefore, SPDI is covered under my Lord 6 and 7. Etc.
Absolutely.
There is no problem.
No problem.
Now, let us look at my political views, which is not SPDI. So, the information in SPDI is not political views.
Absolutely.
That is, my Lord, simply personal information or PI. PI, my Lord, is covered under 5.3 because 5.3 is not a subset of 5.1. Kindly see 5.1 for a minute, my Lord. 5.1, my Lord, it deals with only SPDI. Whereas 5.3, my lords, deals with any information that I collect.
That I mentioned.
And therefore, my lords, that information in 5.3 is a larger set, for example.
Assuming we are not inclined to accept it.
Yes.
Just for the sake of argument.
Hypothetically, my lords, that's not correct.
Hypothetically. Would they then make out a case for our hearing this matter?
No, my lords, the answer is no. Because even hypothetically, my lords, if your lordships were to say that no, 5.3 does not cover, I am, my lords, under 4 required to give a privacy policy. That privacy policy must show who is the intended recipient of the information. And if my friend does not want it, he did not subscribe to it.
All right. Therefore, now I'm not using the word the cat is out of the bag, but with reference to 73A,
please.
The
72
is linked with the presence or absence of a contract.
Therefore, my lords, when I'm giving the private
consent, in other words, irrespective of consent, what you're going to say is that since we have already got a contract with you, which permits you to actually, divulge information, which is personal information, PI as you put it, you're out of the set of obligations which would apply in respect of that PV, whatever it is.
SPDI. Malak, may watch that. I want to spark one step, Malak, just one more step. Academically.
No,
yes, I'm not on Malak's whether WhatsApp, Google, etc. Now, academically, Malak, one step forward is this.
Yeah.
If the state is providing essential service for which information is being collected, the citizen or the recipient of that service has no option but to, my lords, access that particular portal and get that information.
Oh, if state wants, you will have to disclose.
Yes. Now, my lords, let's look at it.
But point is the storage itself.
Yes, my lords.
Because state will want if they know you have a storage of this information.
Yes, my lords.
And in some kind of filing.
Please.
In the cloud or wherever.
Please.
So how are you profile each person, each subscriber. Then what is he looking at in Wikipedia? What kind of song is he listening to? What kind of things he is buying through Amazon? So you are coalescing all this information and helping profiling a person on some unknown category.
See, initially WhatsApp, as far as I know,
advertisement
was in fact charging for the service.
Yes, briefly.
Thereafter,
we don't charge for the service.
You don't charge.
We don't charge.
Initially, they were.
India never charged. Once in India, we never charged.
No, I'm saying world over. We are talking about India alone.
World.
So then after they change the policy, so obviously there is a business consideration. Obviously nobody is a
There must be, Madhur.
Nobody is, they are not doing it for.
Madhur, I hope, Madhur, there's nothing wrong with that, Madhur, to have a business consideration.
Doing charity, but
Yeah.
nothing wrong with, but it's not exactly charity.
It cannot be, Madhur. It cannot
Exactly.
be. Cannot be.
So they are making, there is a sort of hidden cost that you are going to reach.
Madhur, who is getting the benefit of that cost? Madhur, the consumer. Madhur, I give you a lot of an example. I give you a make my trip, Madhur. If I give an example, make my trip, Madhur, then make my trip. I say I've been to Australia 5 times. That information is known to make my trip, Madhur. Make my trip, Madhur, is now advertising. Is advertising. Whereas when it advertises, it can use that information to give me that, look, in the next 6 months or next 1 year, there's a discount of 50% on that trip. Now, what's
It has got both good and bad.
No, I'm just saying, this is the way the world is working now.
You're right. I mean, the good and bad is there.
Yeah.
I mean, WhatsApp.
So they'll take care of the bad and we'll take care of the good, Manoj.
We actually enjoy life. There's no doubt about it.
Whether you get a personalized experience, it is not used for against the individual, it is to enhance his experience.
That is Einstein's theory of relativity is applicable to that personalized experience. It's relative.
No, but the individual, Manoj, if he wants
what you meant to say.
if he doesn't want, he can stop it, Manoj.
What you meant to say was when you say personalized.
Manoj, may I?
Exactly personalized.
All right, Manoj, let me put it this way. If he doesn't want any information to be used, he can only be on WhatsApp and need not be on Facebook. Nothing will be used. He'll not get any ad also. But what he wants is, he wants to be on Facebook. He wants to be on WhatsApp. He wants the advantage, and then he tells you that you don't give me advertisements. How can that be? Well, please appreciate. If he doesn't want any of this, he can be on WhatsApp. He'll be fully protected.
This dichotomy.
Whereas I am only on WhatsApp. I'm not on Facebook. I never get an
Right, let us record that statement of Mr. Sibal right away, please. That if you are on WhatsApp and you are not on Facebook, no information from WhatsApp will be shared.
No advertisement will.
Please allow him to record. Please
Yes,
record
record
that
it.
statement.
Record
Please
it.
record that statement here and now. First and foremost.
No advertisement will
A
come.
large number of
Hold on. Please record
no
my
information, my learned friend says,
please.
will be shared by WhatsApp with Facebook. Please record
allow-
that.
record-
And that solves a large number of my problems.
All right. Very good. Now, let record my statement that no, if I am on WhatsApp
That's
alone,
the closing this.
No, well, it might result in a
Malaj,
benefit.
please record my statement that if I am on WhatsApp, I will not get in any advertisement on WhatsApp.
No, that's not the statement.
That's what. If I
So Mr. Diwan wants that if in the event I am on
both on
WhatsApp,
Facebook,
I am not on Facebook.
yes,
That
you will not get advertisement.
Either way,
No information from WhatsApp would be shared with Facebook.
Yes.
either way, if I'm on WhatsApp,
Well, if you,
whether I'm on Facebook or not, you're not going to. That's how I understood the statement that we don't share and we will continue.
Well,
That's
don't
not the
ask
statement.
me.
There's no problem now.
I was taking the example of make my trip.
At some point, we must be allowed to also.
Let us not make my trip. What Mr. Sibal has been submitting so far, as we have understood, you may correct us, that if a person is only on WhatsApp and is also not a user of Facebook, then the data that is available with WhatsApp, which they don't use, they are not going to share it with Facebook. This is what you are saying. Don't go into the sponsors and advertisements, etc. And that is what Mr. Diwan is now trying to tell us, that if this be the stand of the client that Mr. Sibal is representing, let it be recorded. Then a large amount of anxiety that they have, that would be assuaged.
Problem there is, Malaj, that sometimes we need to share the phone number depending on if there is some violation of any law. But no, we have to share that. That's part of our policy.
Of law, state agency asking for it, that's another.
That's all.
Malaj, if you do some wrong practice, we'll block you from Facebook.
No, those are exceptions.
But that's all that is.
What is your general?
Those are the only things that are there.
Is your general policy, as we have understood, and as you have stated before us, that if somebody who is on WhatsApp
Yes.
and is not on Facebook
Won't get
then
advertisement.
the data that is available with WhatsApp will not be shared with Facebook. Is that what your category?
That data is of no use to us, Manoj.
No. That's not.
Lord, we'll have to be very clear what we mean by data, what we mean by
Exactly.
That's the most important.
Right,
The phone number.
Yes.
Which is what I seek to at some point explain.
No, you may explain it, but the phone number will be known.
The basics.
Basic subscriber information is what we call it, is known. That's all.
Lord, I'll give example. I'm not on, personally, I'm only on WhatsApp. I'm not on any social
Same
media.
with me.
Only on WhatsApp. Now, what does Facebook know about me?
Nothing.
Except the BSI. I'm not on Facebook at all. I'm not on Instagram. I'm not on any media.
I am also personally only on WhatsApp. I have nothing to do with Facebook. I never get any advertisement. But in answering Justice Roy's question, there is one exception. Suppose I am on WhatsApp only, me or Datar. But my lord, suppose on my phone there is some child pornography video shared on WhatsApp. It's possible. My lord, the moment that happens, WhatsApp, my lord, in its security, and it is a complaint, WhatsApp security concerns will pick it up. It will first, my lord, disconnect his WhatsApp also. He'll be chucked out of the system if it is found. And that fact that this man's or this phone number was indulging on this in WhatsApp will be sent to Facebook because the owner is the same. So that if after 2 months I want to join Facebook, I will be prohibited from joining. So that's the only security related
That's what I
issue.
said.
I did a case of a person whose WhatsApp account was closed by them, by WhatsApp.
How would you know whether child pornography?
Report. There's a reporting mechanism.
By a complaint.
Reporting
By a
mechanism.
complaint.
Yes.
Because WhatsApp can't read me or otherwise.
That's right. The person, Manoj, will report it to the authority. The person who is seeing the child pornography.
Okay.
And then the action will take place.
It would be on the basis of a third party.
Yes.
Not us. We can't see anything.
There is an inbuilt report mechanism also.
As the Supreme Court.
The Supreme Court directed us
India.
that you have them. So if this kind of thing happens, I have done an actual case where a man said, my lord, that he has never done it. His phone was utilized to send, my lord, a child pornographic video from A phone to B phone. The moment that happened, it was picked up or there was a complaint, that person's WhatsApp account was closed forever. So he went to a court and said, now why should it be closed, etc. Then it was found this happened. So that's the only security thing, my lord. Otherwise, WhatsApp can't read, WhatsApp can't do anything. And since for both of us, we are not on Facebook, we don't get any advice.
That is an exception theory.
But
That's what I was saying.
That is what we were saying.
That's all.
If that is an exception theory,
Yes.
then what is the difficulty? That barring contingencies such as this,
Yes.
we don't share it. That is
Yes.
what the other side's anxiety is. And should you not be saying upfront that this is our policy? You have said so.
Yes, we've said so.
Not that you have not
Without
said.
the great respect what Mr. Sibal was saying. Take that example. Today WhatsApp is free.
Well, what they want is they want the free service and they don't want
Please note that WhatsApp is free today. Everything, there is no free lunch in this world. Everybody has to pay something for something. WhatsApp is free today. So there is a business model in which, if a phone number is shared with Facebook and then Make My Trip is used, then that advertisement of Make My Trip will pop up on that Facebook account.
Not on WhatsApp.
Not on WhatsApp. Suppose, let me give an example.
It's only Kirana shops.
Suppose, you are on Facebook, you are looking at, let's say, a particular level of cars. Suppose you're looking at a particular level of cars. So I'm looking at cars which are 50 lakhs and above.
That is only for you people, not for us.
So, let's take an example, not 50 lakhs or 10 lakhs. If I'm looking at a 10 lakh car, you have a choice. So you have a choice of Maruti, Hyundai, etc., etc.
That's not 10 lakhs. 10 lakhs. Well, my learned friend has no idea of the pricing mechanism.
Some Maruti, I'm sure some Maruti is 10 lakhs. So, those advertisements, knowing your propensity to look at that level, will pop up. You're looking at Maruti for 10 lakhs. It will say, see also Hyundai. See also this. That's what will happen. And then Then some, my lord, Google, for example. There is a model with Google. Every time that advertisement pops up and the person clicks on the advertisement only to see, not to buy, Google, my lord, will get 1 rupee. Google will get 1 rupee from Maruti because that man has clicked to see whether he has bought or not is not relevant. And that happens across the world. How does Google make money, my lord? All this is free.
On hits.
All this is free. You download WhatsApp. You know,
YouTube also the same.
YouTube, all this is happening in the world. Huge investments are there. It is not meant to be given free for everything at all times. So therefore, there is some business model. That's why this advertisement of Make My Trip. So if you are doing, Make My Trip, say you are booking, Air India. So an advertisement pop up, see related. You press that, it will say BA. It will say, Virgin. It will say this. It will say that. You look at Make My Trip.
Rohtagi is always talking about this Make My Trip. You're making use of it. It's very clear.
I have done some cases for them, my lord. They have been, damned in the competition commission. From 500 to 300 crores fine was imposed on them. So if you see Make My Trip, my lord, there are 5 other, my lord, similar holiday trip, this trip, that trip. That's what happens. So it's not as if that, my lord, some sensitive, there are cases of sexual orientations, right? They have never said, my lord. So if somebody is, my lord, and now the point is, you want to be within the app, you want to utilize the app also, and say now you tune it the way I want you to tune it. Then don't take the app. These
That's
are
what the
private.
rule also says, Mother.
So, no, one more thing, my lord, please note. These are private companies. These are private companies. They are not state. They are private companies across the world. If you want to use it in this form with our explanation that we are not sharing any personal sensitive information. Otherwise, don't use it.
Options are there.
The problem is, Mother, there is what is called
There
a
is what's
business
Telegram.
messaging service. There's a business messaging service. If you are both on WhatsApp and Facebook, then this happens of Make My Trip balance and stuff.
Yeah.
Not otherwise.
It doesn't happen.
So let's, Mother.
These are, these are also issues that can you insist that I must take your service also and you must do it this way also. Please don't take it then.
And the rule says that if you don't agree, I can cut
You
off
have,
the service.
they are alternate services. There are alternate. Telegram is an alternate service.
That's right.
You have bought him. You have bought him.
It's said to be more secure.
Supposedly more secure. You have bought him. You have Telegram. You have
Signal.
You have Signal.
You have Signal, Mother.
Viber.
So many of them.
You can take any service. Just like you make a WhatsApp call, below. You can make a bought him call.
Mother, the simple thing is if 600 million people are on this service, Mother, has anyone has complained that my sensitive or other information is being misused?
There's a cause of
It's as simple as that. There's no cause of action. This is all in the air in the rules.
No cause of action.
And nobody has ever said. Then why, Mother, if this is what...
90,000 people don't know.
Well, I'm sorry.
Out of these 6 lakh, 5 lakh 90,000.
Let's assume that. Let's assume that at least 10,000 people one would have complained. What is the? Well, there is no data before you on it.
We have been hearing the reverse order actually.
All right, let us
Give them some
start.
time.
You'll want to start.
Some time, let us see what they have to do. Why don't we make up our mind whether we should really go ahead or just finish? What do you say?
Yes, I'm very grateful. Thank you. Now, I'll just very broadly indicate what I took away from some of the submissions which were made. The first point I take away is what Mr. Datar stated and what Mr. Sibal and Mr. Rodge, etc. have elaborated. Their case is, or what they projected is, that there is an extant or existing legal regime. And their endeavor was to project that they are in compliance with that extant legal regime. That takes care of a huge problem or a huge issue which was raised yesterday, namely that all of this is in a vacuum, this is speculative, we have to await the data protection law, etc. If there is a regime, if the government is confident about its regime, that it is adequate, inadequate, there can always be further and future legislative changes. There is no impediment in terms of this court proceeding to hear the matter in the light of the existing legal framework, which includes the statutory framework which has been pointed out. So there is, according to them, an adequate and robust legal and statutory framework That can, of course, be improved, altered, changed, etc. But your lordships will not be disadvantaged by not having any law to guide you in terms of statute law. So that, I believe, takes care of one set of objections. The second point is a very important point which the court put to us. And here, Manoj, I have consulted my colleagues. We will complete arguments on this side by next Wednesday evening, and at the very latest by Thursday. If we fail to complete that, we'll supplement it with written arguments. So next Wednesday evening is our target. At the most, it will go on till next Thursday. They will have the whole of the rest of February to argue, and many weeks if they require that in the month of March to argue. But we will complete and stick and adhere to our time frame of next Wednesday evening. At the most, maybe a spillover into the end of next week. That's the second element. There will be more than adequate time to deal with this. The third element which I want to just point out, and here your lordship may take up the orders file passed by this court, or you needn't go to it because I'll just summarize it. Way back in 2017, and at that time, Mr. Rothgi was Attorney General, and we have the news reports which we have also placed on record. And assurance was extended to the Constitution Bench in April 17 that an act will be passed by Diwali. That was how it was reported in the news items. Our court records it in the order slightly differently. But be that as it may, this issue or this particular subject of introducing a bill, when it will come about, etc., is entirely in the realm of speculation. I think your lordship should not or ought not, having regard to the fact that they say that there is already an existing regime, speculate on what form it will take, when it will pass, etc., particularly since we have been waiting, your lordships, in the month of September 2022, noticed this very bench noticed this. And you had a raft of cases, constitutional bench cases before you. You kept certain matters earlier and sooner, having regard to the Solicitor General's statement that, look, there is likelihood of a bill, etc. A longer date into January was given. And now this matter has been pending for 5.5 years plus before a constitutional bench and for 6 years before this honorable court when it has come over here. Now, my lords, I just want to step aside a little bit about what this case is about. When you saw the Information Technology Act, and your lordship noticed that section which was pointed out, it was, as you noticed from the 43A marginal note, compensation for failure to protect data. Now, there are two broad elements to this case. The first broad element, which is a very valid element, is data protection. Data protection essentially means that in this electronic age, various persons who are extending service come up with a mass of data. That data is required to be protected by the service provider. And if there is a data breach, there is a visitation of penalty and there is a detailing in terms of the rules as to what happens if there's a data breach. This is a data breach concept. There's a separate, completely separate concept which comes out from what Mr. Rothgi mentioned and what we have in the documents which we have placed before you also filed. There is an author whom we have extracted, Shoshana Zuboff, and she describes this as surveillance capitalism. That's her expression, not mine. And I want to spend a few minutes on what is that concept. That is not a concept of data breach, which is being spoken of in the context of 43A and the regulations. That notion is that data in today's world has an enormous commercial value. And that data, which has enormous commercial value, comprises not only what individual data in terms of personal sensitive data, but also a whole notion of metadata. Because as we will see from the material which we have already placed and filed, because your lordships were good enough to request all the AORs to come together and file a convenience compilation, which is also available before the court, that will show the manner in which this particular even metadata, not the specifics, but the larger issues with regard to when a person, for example, engages in WhatsApp activity, the time zones, etc., that itself has an enormous commercial value. Now, this commercial value is being exploited wrongfully, according to us, by WhatsApp sharing this data with Meta or the Facebook group of companies. On the issue of political speech, they have in December 2022, Meta has entered into a settlement, which we will draw your lordship's attention to very shortly. But in that settlement, in the class action settlement of December 2022, Meta paid out $725 million, because I'm only mentioning this because that was a political speech Cambridge Analytica issue where they had granted third-party access to Facebook users, etc. And there's a whole. So I'm not concerned with that. I'm just giving you an element and a detailed question. Now, what is this nature? What is the nature of the data which they may share? What is the value of this particular commercial data? All of that we seek to explain and project before this court, because this, at the end of the day, is a new policy which they introduced in 2016. So let me just broadly give you, well, just a few milestones. When WhatsApp introduced their program, the messaging service, they made an assurance to the world at large, please use us. We are not interested in advertising in any manner. We are not going to part with your data to anyone at all. That was the representative. Now, the way capitalism works, and there's nothing wrong with that, is the valuation, this message, and the garnering of thousands and thousands of users, as far as WhatsApp is concerned, increase the valuation of WhatsApp, because they had a larger and expanded user base. So they attracted and received more capital, and then they were able to improve the service even greater. Then right through, even in the immediate aftermath of Facebook buying WhatsApp and taking over WhatsApp, the assurance on privacy and the not sharing of data continued to extend. Then all of a sudden in 2016, they suddenly change and alter their policy. So the law as we understand it is that yes, as far as data collected from a service is concerned, there is a purpose limitation. You can certainly use that data, for example, to technically improve the quality of the service which you are giving. And moving forward, we have the advantage of their own practice with this very messaging service to European users. So it's not as if WhatsApp doesn't work in Europe. It works very effectively in Europe. And therefore, what our request is that you furnish an undertaking that, look, just as you did before the European data protection regime kicked in, that we will not share any of the data. WhatsApp's assurance and undertaking to the European regulators that we will not share any of the data with WhatsApp, with Facebook at that point of time. And that is the nature of the assurance we request, because according to us, it's a matter of right in terms of the law which is laid down. Now, with your permission, may I just hand over, just because there were questions which were asked, just what we were hoping that to sort of tempt the court. I've noticed that the court has said that till the lunch interval, your lordship will contemplate this. But this is what I would have handed over, because I thought I was going to start tracking yesterday. So anyway, I have just handed this over, and we'll give copies to the other side as well. It is what we have titled as opening submissions. I'm sorry. Yes.
Into contracts with them. Each user,
yes,
including your client,
right,
would have entered into a contract in the electronic form of subject to
yeah,
agreeing to all this.
Yeah.
Now, if a particular user has actually entered into a contract permitting them,
yes,
to transfer data, rival data,
yes, yes,
Facebook or to somebody else,
correct.
Then can you come?
So can I just answer that straight away? So let me just answer that in one sentence, and then we'll move on. the standard which according to us ought to be applied, and I had just hinted at that briefly yesterday, is there ought to be first two elements: informed consent when you take the agreement, etc., and second and most important, an opt-out option. An opt-out option that, look, I don't want to give this service. So if someone wants to receive advertisements, by all means, we are not saying that the person should not receive advertisements on Facebook or anywhere else. But if he or she at any point of time, which is exactly what is being done insofar as Europe is concerned, if you have an opt-out option, then no one can complain. I want an option to opt out of this data sharing onwards. So there may be certain elements which they just cannot share because it's visited by penalty and there is a complete embargo. There may be other elements which, as the court correctly puts to me, could be the subject matter of contract. But even that will be within the overarching principles laid down and recognized by this court and applied by this court, not just recognized by this court, and applied by this court on, for example, I'm indicating purpose limitation. Now, obviously, we are going to have to explain all of this as to what it will comprise of and what it will mean, etc. But what is purpose limitation? How far can you go, etc.? Now, I'm answering a question which the court had put a little earlier. Please go. We have tab here. There are a large number of tabs in what I've just handed over. Please go to E. Sorry. Yes.
You are saying that your real complaint is that you are not being permitted to opt out.
Right.
Opt out.
Yeah.
Can you just explain that a little bit?
Of course I can. So what happens is,
we can put it to that side.
Yes. So, Millers, to simplify, because there will be, and I've enumerated those requests, etc. By opt out, what I mean is that an option is given to a user of WhatsApp.
You mean
to the user.
No, you are actually writing for a particular petitioner.
Yes, I am for two petitioners. They are the two writ petitioners who were there before the High Court and who are now in SLP.
So the relief which you are seeking will be limited to those two petitioners.
I suppose it will be a general policy. So I guess if it's an option to me, I'd be very happy if it's limited. But I suppose there would be.
Petition which is a PI.
Internet Freedom Federation to intervene on any of the same relief.
Same relief.
Okay. Opt out.
Opt out of the sharing of data.
Yes.
Not from the side.
Follow.
It's a saying, take it or leave it.
So you don't want to leave WhatsApp or Facebook. You want to get the best of both worlds.
Yes.
And you want the data not to be shared.
Differentially supported, large corporations, cannot take this stand. It is well said in here.
So then what happens to the validity of the contract? Are we not indirectly?
These are illegal contracts. Law states held not to be informed.
No, but are we not allowing you to renege on a solemn contract?
No, it's not, Manoj. It's not.
As a public law.
We'll develop that, Manoj. We'll have to develop that. But that is certainly an issue on which we will address and assist the court.
We may have operation for the future. That somebody who wants to newly join WhatsApp, we can perhaps say that. What about you?
We are users who are pre-2016.
Exactly.
And if we are pre-16, we are entitled to continue on the terms and on the basis of the representations which you gave. Because WhatsApp, this is the argument which we will develop and we will explain it in the context of Indian law and we will explain it in the context of global human rights law, which is binding on transnational corporations itself, which operate in multiple jurisdictions. So there are
What? You would have also done that. We do it from time to time. They give, what's called revised
terms.
Right. And all of us click in because we need to do that.
Right.
Otherwise, it simply doesn't operate. So when you did that, when your clients did that, would you not have entered into this contract?
So to answer the question, we have not done that.
Where you have agreed for, transfer data.
So two things I'm just telling you.
Because we keep doing that all the time.
Yes. So
I don't even know how to do it. My son does it for me.
Very well. But I'll just indicate. So in the case of these individual petitioners, they have not opted for that particular. They haven't clicked on it.
You call it update, I think. What is it?
It's an update. There is now there are two categories in India. So there will be one set of people who have opted because, as your lordship said, something comes and you immediately agree, right? For them, again, moving forward, according to us, if we are correct, according to us, they must and are required by law to amend their policy to ensure an opt-out option for the future. Even an option. So you may have agreed so far, but you must, that's according to us, an element and a basic element and a requirement of privacy, which we will develop and explain.
But
That's one. Second, I'm sorry.
Perhaps they would be doing that under Rule 4.
So,
Time to time.
so, my lords, on the rules, let me just answer you. Just let me indicate the stand of the government of India is on record. And according to them, in fact, we put it in this brief compilation which I've handed over right now, where according to them, WhatsApp is violating. But I'm not into the government of India and their stand on 2011. They have written a letter communication and they've given a tabulated statement. So that the government of India is sort of sure to project its own case. I am now focusing on the concerns because your lordship put to us, what are our broad concerns? Yes. Now that please go to tab E. Tab E. Give it to them. No? Okay. At tab E, do you have personal data collected by WhatsApp and disclosed to Facebook and the Facebook company? Yes, we got that. Your lordship has that heading. So I'm not going to read the whole of it because I realize that we are at a preliminary stage, but just to give you a flavor, please see in red, the personal data highlighted in red font is data that WhatsApp either does not collect or collects at the option of users or claims to keep end-to-end encrypted in certain other jurisdictions. All right. So we have flagged the issues which are red. Then I will get into all these details at a subsequent point. Please go straight away to capital C at page 3. Capital C at internal page 3 of tab E.
Yeah.
Now this, please allow me to read. How WhatsApp uses this personal data. We've given you the reference in the convenience compilation, etc. Shared with Facebook and Facebook companies. As stated above, WhatsApp shares users' personal data with Facebook and Facebook companies so that they are able to understand how users use their service, to customize and improve their service offerings, and for marketing of their services, irrespective of whether the users have an independent agreement with Facebook or the Facebook companies. This is not limited to making marketing or advertising suggestions, but also includes personalization of content as well as based on user behavior and interaction. The personal data of WhatsApp users is also utilized by Facebook and Facebook companies to show relevant offers and ads across Facebook company products. So here, please, just since an observation was made earlier, there's also political speech because on Facebook, you will get a feed of news articles also based on your metadata, which their algorithms are calculating. So it's not just advertisements. Now, please read on. Yeah. In certain other jurisdictions, WhatsApp assures that any information shared with Facebook and Facebook companies is only used by them in accordance with its instructions and terms. The Facebook and Facebook companies are not permitted to use personal data of WhatsApp users for advertising/marketing purposes or their own commercial benefit. So this is one difference which we have spotted. We will explain that and endeavor to explain that. Now please go to D, capital D at the foot of page 4. Other differences between the 2021 privacy policy offered in India and that offered in certain other jurisdictions. WhatsApp provides a granular and comprehensive list of what personal data is required for exactly what purpose or what function. This is under a section titled Processing Necessary for WhatsApp to Perform its Contract. This disclosure is completely absent from the policy applicable in India. So they disclose, itemize, and I'll take you to the tables. They don't do it here. They do it in certain other jurisdictions. WhatsApp allows users of certain other jurisdictions to exercise the right to object to processing of their personal information for direct marketing purposes and the right to object to processing of their information where WhatsApp claims to be pursuing its legitimate interests or those of a third party. In considering such an objection, WhatsApp will consider several factors such as users' reasonable expectations, the benefits and risks to users, to WhatsApp, to its other users, third parties, and other available means to achieve the same purpose that may be less invasive and do not require a disproportionate effort. 3. The user's objections will be upheld and WhatsApp will cease processing of their information unless it is based on compelling legitimate grounds or is needed for legal reasons. These rights are provided. So these are users' rights. These rights are provided under a section titled How to Exercise Your Rights. This section and right made available to the users is completely absent from the policy applicable in India. 4. In certain other jurisdictions, WhatsApp specifies that information is retained for what period. This is under the section Retention of Information, and this section is completely absent from the policy applicable in India. On the contrary, the FAQ attached to the Indian privacy policy contains entirely vague stipulations, including to the effect that even after a deletion of a user's account, her data may be retained by WhatsApp for an indefinite period. 5. The policy provides for an in-app/web form to contact WhatsApp's data protection officer in the 2021 privacy policy, and only a postal address is given insofar as California is concerned. So there are other details also which we have highlighted over here. I've just given you a flavor in terms of para C1, the last part at the top of para 4, in the context of what we have set out in C1, and also the concerns in terms of B, where there is a huge disparity and a difference in terms of what they do with the data and how they can commercially utilize it. This is broadly going to be the thrust insofar as this case is concerned. Now, as far as WhatsApp and Meta is concerned, if your lordship, I did make a reference, if your lordship is just pleased to go in tab D, your lordship may just go to page 29. Now, this is, do your lordship have a list of fines, penalties, settlements of WhatsApp at page 29?
Just before that.
Yes, certainly.
One question.
Yes, of course.
The argument is that actually comparing ourselves.
One of my arguments.
With what is obtaining in Europe.
That's one of my.
Rather than what is being permitted or done in the US.
US. Yeah, all right, very well. In India, well, I'll say in India.
That's right. No. If it is, when you're talking about Article 14.
Yeah.
Classification is permissible, classification is lawful.
No, I'm not saying 14 applies in this.
So what is your, how do you
all right. So let me just indicate the constitutional point over here. My constitutional substratum is this. It's broadly in respect of the right to privacy, which your lordships have articulated at great length in the 9-judge bench judgment, which I'm going to place before this court, and also applied those tests in the Aadhaar case, which goes by the same name, Justice Puttaswamy, but the 5-judge bench. So we will place those decisions before the court. Now, elements of privacy are drawn not to one particular article itself, but there is a whole fasciculus of articles, a whole set of articles, and privacy has been held by your lordships while emanating or rooted in several articles to be absolutely necessary to exercise the fundamental rights which have been guaranteed to us. Now, in this backdrop, privacy is anchored in more than one article under the Constitution. Now, what is our submission? Our submission is that as far as the fundamental right to privacy is concerned, there is clearly privacy recognized as a fundamental right qua the state. No doubt about that. There are also observations which have been made by this court that privacy, this is in the Puttaswamy judgment, has a certain horizontal element as well, which means that it extends beyond or emanates beyond the state to non-state actors as well. Now that can happen in a traditional manner, which is that the union government is also here, and therefore an appropriate direction be issued to the union government if it is found wanting to say that, look, the privacy of fundamental rights of citizens is being affected. Therefore, you please take further and appropriate action. That's the conventional way of doing it. That's exactly the manner in which your lordships have extended this jurisdiction, for example, in a whole host of environmental cases, where against private polluters, the case is that you, the Pollution Control Board, or you, the Ministry of Environment and Forests, please do your job better or more intensely, because there is a fundamental right to life. That right is against the state, but it has to be ensured because there's such a violation or a breach in a hypothetical case by a private player that it must go there, you must go there and take action. So that is one element of my case. The second element of my case is also founded on transnational human rights law. If you are, as a corporation, recognizing this as a privacy right, then it's our understanding and our submission that the best standard as far as privacy is concerned. Look, it's not our case that every element has to be adopted in India. There may be technical requirements which India requires. There may be technical requirements which other jurisdictions require. That we are not suggesting for a moment that everything which WhatsApp does has to be planted and adopted over here. No. Of course, our laws and laws generally will have a local or territorial reach. But on this element of privacy and on this element of the model in terms of data exploitation, I'll use the expression exploitation, or data usage for commercial gain, etc., the standards are no different according to us, whether you are a European citizen where you are already doing this and us. So my stand is twofold. My respectful submission is that ignore Europe. Europe, which we were putting forward to, was in the context because you're already doing it there. So that becomes easy. You as in WhatsApp, can't raise a technical objection, oh, that this is not possible, that this is too expensive. You're doing it. So that is one part of the problem solved.
Mr. Diwan,
yes, I'm sorry.
Just the European approach.
Yeah.
Privacy is absolutism. It cannot
really.
Be, broadly, I'm speaking, cannot be breached. Whereas other jurisdictions, like US, it's more of a monetization, that it can be traded.
Yes.
This is the broad difference. So it's essentially a matter of policy in what way.
So, may I just answer that point itself?
Yes.
I think a large amount of this.
I may be wrong in my.
No, I will. It's for others to correct the characterization, but I take it as completely accurate at this point. And I would respectfully submit that is exactly where the option out or the option after an informed consent, that yes, if you tell a user that, look, we will not necessarily use your data and you have an option and you can opt out, which is the European model, and you have a complaints mechanism, etc., where if there's something goes wrong, etc., it can be done. Not a complaint in the context of data breaches. It's very different. A data breach or a data violation where some data is leaked may invite penalties and prosecutorial action because you did not, that's a security issue. I am not on the security issue at all. I am on the commercial exploitation issue. The commercial exploitation issue by WhatsApp, and this will be in a context. The context which we will seek to explain is that, look, these are the stages through which WhatsApp developed and expanded its footprint till 2016. You are bound by those promises qua privacy. You may have other promises, etc. And obviously the world is changing and altering, and there may be certain technical parameters, etc., which may change. But on this element of privacy and on this element of exploitation of metadata and selling it to, or not selling it, but parting with it to Facebook group of companies, according to us, is proscribed as a matter of Indian law. It's proscribed as a matter of the explanations under 21 by our bench under in Puttaswamy, etc. It's proscribed possibly, according to us. Also, if your lordships are finally persuaded to accept this, under their obligations as a transnational corporation, it must respect. So, Manoj, I am fully in agreement with what your lordship says. Different jurisdictions may have a different approach to privacy. There may be an absolute approach, there may be a policy issue, etc., and there may be a trade-off. But the option which we are requesting, so informed consent, not take it or leave it. Your lordships heard, they were very plain about what they said. They said, if you want my service, take it. According to us, that's not the law. According to us, an understanding of how this has entirely developed, how WhatsApp base has developed, their commercial model representing right through and then suddenly altering it for certain jurisdictions, not altering it for other jurisdictions is impermissible. So, my lords, I'm sure there are others who would like to address your lordships before the lunch interval as well. I would respectfully urge that, look, we have, I mean, we are ultimately at, of course, there may be some supervening circumstances, but the supervening circumstances normally before a constitution bench, as I understand their name, someone is unwell, etc. Or there is a matter which is of grave urgency, which sort of leapfrogs and has to be taken up early or quickly. If those are the kind of considerations, of course, this case would stand over. But I don't believe, my lords, the prospect that a bill may be introduced and may be debated and should be passed in the facts of this case. Not that I am for a moment suggesting that it's all bona fide. But the Attorney General in 2017 also bona fide had said that, look, we are expecting a bill by Diwali in 2017. So these things, my lords, often take longer. And I would respectfully urge that we are here to assist the court. We would really like to do so on the merits. I'm very grateful.
Yeah. Your item?
I am Milord Internet Freedom Federation in the same matter as well.
That's a repetition here.
That is an intervention application announced by Milord Your Lordship in 2017.
Oh, you're in which case?
In the first matter, Milord.
Where-
First matter, yeah, in the first matter. Karmanya Singh Sareen's matter. There is an order of 27th April 17.
That's right. The same matter with
Same matter, same.
You're supporting him.
We are completely supporting him and supplementing Milord the submissions. Milord, my Lord, the Honorable Justice Bose asked them pointedly, what is it that you are now sharing? They answered about sensitive personal data, but other than sensitive personal data, their own policy, my Lord, sets out what they are automatically collecting. Your Lordship, you just go to volume 10 of the convenience compilation. It's only one paragraph which sets out, my Lord, exactly what they collect and what, my Lord, they will share with this I agree, which, my Lord, they say they have taken from us. What is the legal effect of this I agree? These claims have been pronounced, my Lord, predominantly by Lord Denning, though, my Lord, about those redlining contracts, my Lord, Taunton and other cases. These were cited in the earlier hearing. But just, my Lord, we have put it in a chart, my Lord, because this is very important, my Lord, as to what is it that our immediate concern is in the 2021 policy. Just have this chart. It is in volume 10, page 3687. Volume 10 of the convenience compilation. If your Lordships will not have these contracts, will not have not informed consent. It is not with full knowledge of, my Lord, what is being sought to be waived.
That can be collectively so many people have entered this.
Your Lordships have given following Lord Denning, Taunton's case, and I'll raise that.
That was in a specific.
It is very graphically put, my Lord, that. But Taunton versus shoe lane parking. I'll place them when it comes to that. And following the other case of Sperling versus Bradshaw and others.
There's a Hamlin lecture.
The
Old judges and Timura's souls.
Lord Atkins, my Lord, actually.
They are these cases.
Yes. Like Lord Atkins used that phrase, I think, my Lord, and
it's in that
Liver City.
51
Liver City.
we All England report.
Yes.
Mr. Vishwanathan,
To Dunay Stevenson.
Yes.
I just want to express myself.
Yes.
From 10:30 to we are just switching off to 1. What we are going to examine is whether we should continue or not to continue. Yes, so
Ultimately,
our request is we have this digital personal data protection bill.
That's correct.
I was just going through this bill. Certain the submissions which Mr. Diwan has made in a modulated form, they have taken note of it. How it will finally formulated is something will come later, not today. What our request to you is, whatever the submissions are made by Diwan and what you want to supplement him, are these submissions have not been taken care of in this draft bill available to us? Because if you find this draft bill,
I saw the draft bill. I examined.
This term has been changed. Sensitive personal data has been changed to only personal data.
They have said consent, deemed consent,
Yes.
all that.
Yes.
It
Our
means,
request-
legislation will evolve.
Our request is,
Yes.
our request is, if you come to this, bill of 22.
Yes, Milord. It is in volume 21, Milord.
Oh, don't go volume 21. Term has been changed.
Yes.
They have made a consolidated, now comes to personal data.
Yes.
In the earlier regime, it was sensitive personal data, the personal data and all things. Now they consolidated and said personal data. And how consent, deemed consent is also defined. Permission with consent, with deemed consent, whatever it is. Now, what our request to you is that we are at the stage when this bill is also maybe introduced, may take months time, 2 months time, and in the process. Now, our request to you is, if the legislature wisdom, with whatever the complaints are being made in a given point of time and before us, legislature is now taking a call to examine as to whether within my own jurisdiction I can take those notice of those particular grievances pointed out to us by a common person in reference to reserve the data. How it's to be formulated, how it's to be used, made it available, not made available, to what extent. Our question to it, are we not supposed to wait for the outcome of that bill of 22 and await the legislative wisdom to place before us? And thereafter you find, no, sorry, this particular provision of the act which finally formulated, still our right to privacy is still not being taken care of by the legislature. Examine it. Somewhere, otherwise what will happen?
Respectfully respond.
What will happen?
We have also
Simultaneously, we are going ahead with the legislation on one side and we on the judicial side.
Privacy is a fundamental right.
I agree with you.
And if every
there can't be any compromise.
There is violation. And if you have come to your lordship with an injunctive relief, including an interim injunctive relief, on which notices have gone, are we not
in 17
for this much parity with the solicitor?
In 17, when Mr. Rothgi was, because everybody said Mr. Rothgi was there as Solicitor General, Attorney General. Is this bill like 22 was there?
No, this was the committee was there. This came, Milord, first in 17 in the draft form. It is noticed, Milord, in the other.
You can see they have gone one step ahead now.
Lordships are not foreclosed from examining, as the learned solicitor said.
Yes.
That he is, Milord, batting for the Indian WhatsApp customers who ought to be put on par, he says, in terms of privacy rights.
That was his first statement.
That was his first statement. But even yesterday he kept saying that I am not in support of the WhatsApp companies insofar as the breach privacy is concerned. If we can show what data they are collecting, this is metadata, Milord. The message is encrypted. Suppose I say good morning back, that will go in encrypted form. But if it is going from me to my cardiologist and that number is stored as a cardiologist, I will get a pop-up on my WhatsApp. It's
completely wrong what he is saying. I don't know what he is saying.
Look, this is the intermediaries, they can collect. Kindly see, Milord, what WhatsApp admits in metadata collection. Diagnostic, kindly see that. Just see this, one paragraph. All that we are saying is give us an option to opt out of that. Till the bill comes, bill is going to say the same thing. I can understand if the bill is going to say something different. Bill is only saying that we are aligning your privacy rights with these regulations. But till the bill comes, just see this.
What the example that you gave.
Yes.
Good morning to my cardiologist.
That was encrypted.
Now, if that is metadata, nothing personal, nothing this thing, it's just a greeting.
No, that message will be encrypted. Nobody is complaining of that message which is typed.
Correct. So,
but the groups which go, the status in the group, all that admittedly will not they collect.
That is that is actually, I mean, it's a commercial element is coming in there.
Mr. Sibal
by
admitted
use of
that
internet.
What is
that targeted advertising happens because of
That's in the business messaging, not, please understand.
Normal,
What-
never happen.
Normal, it doesn't happen. It's a business messaging
Not that
platform,
business they
which was
take-
introduced in 2018. I understand is completely
you
wrong.
either agree or you don't agree. Milord, just see this, Milord, what they admit in their policy. Milord. Just see this chart. Does WhatsApp collect? This chart, I'll take it as red. Milord. This is what my lord wanted about the data.
I will tell you.
215, huh? Sorry, there is a.
we deliberated about whether to hear or not to hear. Now, we are inclined to hear it out except one caveat. Certain logistic reasons, sides by February 20th, 21st.
We will finish. On our side,
Because we have a
try and
constitutional
curtail by
bench. I have the Maharashtra constitutional bench starting on 14. There's no way we can finish it. No way.
Yes, Mr. Attorney, what is?
Yeah, I think my hands are also on two constitutions. There are some and some other.
Immediately after that is Assam.
Yes. I have one small concern. Lordships hearing this matter, of course, all are laid bare.
And postpone it beyond those constitution benches, then this composition possibly would
We see that. We see that.
available.
We see that.
Plus, we'll endeavor to complete it.
No, but we cannot. I mean, we must honestly tell the
The other
court.
side,
No, but
we wanted a
And then when
we can do no better than confine
I'll
our
have to
arguments
show
to
your
the
lordships the
submission
facts. No,
and request the other side also to whatever adjust their sequence, etc., depending on the court's convenience. If it's a constitutional bench, we have to all make an adjustment.
You see, just see the dates, huh? Today, we are just 1/2 day, we have just begun. So tomorrow is a Thursday. So anyway, they have agreed to complete it, whatever come what may, by Thursday. Yes. Which is the 9th of February. Correct? So that is 5 days for them. Okay. You start on the 14, 15, 16.
We can't.
And you can take 21, 22, and 23 also.
Even 14th is the Maharashtra matter where I have to open Malats, the constitutional bench matter, Malats. It's already fixed.
But then others who are there who can go on.
But Malats, I mean, the point is that we have been working on it for 10 years, Malats. Surely, Malats, you're
That's all the more reason we are.
But the point is, he's appearing for WhatsApp, which is the main.
Malats, I have to really
main
respond.
focus.
Nobody else is really for
But then
WhatsApp.
you're also part of our constitution.
I agree, Malats, but all I'm saying is your lordship asked us the timeline. I'm not saying anything, Malats. Your lordship asked us, therefore we are saying. If your lordship hadn't asked,
the 23rd,
that's not.
then we can make an attempt to. Otherwise, no.
But we'll make an attempt, but let's complete it. Let me start now and go on with it.
No. CapilSibal, we don't want to abandon.
No, of course, I don't think there'll be any question of abandonment. I don't.
We can honestly tell your lordship.
No, there can't be a waste of time at all. We have to all arrange our.
Issues are multiple. We'll have to give
The court is sitting, the court is in session, it's a constitution bench.
Whole days.
Manoj, no, these are very. Manoj, we have prepared so much data for your lordships, Manoj, on these matters. There are 4 separate matters. This can't finish, Manoj, like that.
So you will complete then, okay, latest by the 2nd of March.
Well, let us stick to what your lordships have indicated. If there's a little spillover, it will all go to their.
I won't be able to.
It will be there. It will be for them to use the time. We will not.
3rd of March, up to 3rd of March you get. I think you get that.
Manoj, when will we start? I don't know, Manoj.
We are starting right now.
Manoj, no, you start now. When will we respond, Manoj? I don't know, Manoj.
Start responding by the 14th of February.
14th is not possible, Manoj, as I told your lordship. Unless Manoj finds somebody else will do it, no problem, Manoj. That's not an issue.
We were prepared to do it. We wanted to do it because this is the only case where we have not, out of the matters assigned, the other 3, which we have
Yes.
heard of. This is only we wanted, we didn't want to leave anything.
That's correct.
What do we do then?
I don't think there's any problem at all. Mr. Sibal, I'm sure will arrange his affairs.
Well,
His client will
I will
arrange his
arrange my
affairs. I'm astonished that I have to even say this.
I am sorry.
The
I am
Constitution
sorry.
bench is
It
ready
is
to
the
hear the
court
matter.
which asked.
The Constitution bench has said that it wants to proceed with the matter. We must proceed.
I-
It is 501.
You are
Please
not
allow
to
me
dictate to
open.
the bench. You are not here to dictate to the bench. The bench.
You're
asked us.
requesting. I mean,
Can
this
we-
is a
can we proceed?
type of request which ought never be made.
The type of
When the
argument
bench is
should never
giving-
be made.
The bench is giving
This kind
3
of
weeks time.
quality of argument should never be made. Forget about request.
Both of us are opposing each other, my lord.
There's also a constitution bench. And by the time
Don't
get
you
to-
think this would be a better court where you are together?
No, no.
Or here also you are opposing.
No, we are opposing. But that was, my lord, fixed, my lord, about, I think more than
These are
Month ago.
month ago.
This was also fixed in
in
September.
September.
The other
No,
matter.
my lord, I can't compare, my lord, two
We are not
constitutional
comparing, my lord.
bench,
We
you know,
love
we
to do
can't.
the matter.
And
It's only a matter of accommodation, my lord. We can't.
Once you begin, you can always tell the other bench that you
No, but
that's
that's-
a partner. You know, we don't have to tell you what you have.
No, but that's difficult.
We know that you.
That's difficult. It's difficult.
Fourteen, my lord. I am not.
Looking to an overall time schedule which you are given to us.
Yes.
You don't think looking to a whole time schedule means the whole February will go? The whole February.
That's what your lordships indicate. We are completing next week. We're going to endeavor to complete by next Wednesday evening.
February.
But with a little spillover, I therefore said certainly by next Thursday. I've taken the consent of all the council on our side. That's very swift, Manoj. We will place, if it's earlier, sooner the better. But my own really request is that let me just start. Let us start and let the matter progress. I will endeavor to complete as soon as possible. If there is some adjustment which is to be made in terms of sequence of a council, etc., first, second, third, that can be
I tell
done.
you, after going through this legislation which is brought to us,
The prospective,
brought to us. I have just read over to us.
the bill, yeah.
Yes, Bill. We find that whatever the submissions were made by you people,
Right.
submission also, to some extent has been taken care of. So what
Let me not comment on it.
Then, my lord, if your lordships are, my lord, prima facie of that view, it's better to wait, my lord. Why?
After the legislation comes into place, we examine as to whether what will be the impact of that
May I just
legislation and
respond?
how far that protect your rights
I
and
understand.
what are the rights which still remain unprotected by the legislation. We'll examine it.
I
In
understand.
fact,
May I
I
just
was
respond to
thinking that
Your
we
lordship
cannot
said-
probably convert it into a 143 reference debate today. The bill will go to the parliament, there will be a debate and to anticipate certain things. So to whichever way, we don't want to say that the courts will
We
not.
closed our arguments on this aspect before the lunch session. Your lordships came back and indicated your mind. We are ready to go on with the matter.
No, correct.
Now, surely we can't have council's convenience to derail.
So who is
a
asking
program
council?
before
I
the
have not,
constitutional bench.
I have not given my convenience. The
That's
court
only-
asked us.
That's the only.
Can you finish?
It's only council's convenience.
Manoj, can't we, Manoj, mention that there's a constitution bench fixed a
It's
month ago,
only
Manoj?
council's convenience.
I am sorry.
It ought not
It
to have
is
been
not.
even mentioned in the court.
You should not be saying this as council.
May I say something?
But I don't know why my learned friend is so vociferous and vehement.
No, my lord, may I say something?
For a date, my lord, we generally, my
They are
lord.
wanting time.
I don't understand.
In UK, when a similar situation arose pending the GDPR, the data protection, they undertook to the commission that they will not share till the GDPR comes into effect. I got the Millard order.
Are you prepared to give that?
That he should give that.
Share what? Share what is it that we are sharing that he doesn't want us to share?
What is it that?
Share the personal information.
What personal information?
Metadata that they may not collect.
Please tell us what it is.
WhatsApp to Facebook.
Please tell us what it is. Please tell us.
It's mentioned in
Is it-
Para 10 of the policy.
No,
Para
no.
8 of the policy will not. What
He's
document?
a petitioner. He is a petitioner. He must tell you what information is being shared. Please tell him, ask him to put an affidavit. Malas, for the last so many years, we have been operating this. Since 2018, the policy came, Malas, the messaging service, messaging service. To what extent the data has been shared, please let him tell us.
Kindly have.
This is all academic.
Can condense your time to do it
Yes.
possible. Otherwise, we can't give the
Yeah,
whole
we
month.
will condense our time.
The whole month to go on one matter. At least for me, it's not possible.
No, we'll condense our time.
Malas, I'm sorry, this will take time. I'm sorry, Malas.
Yeah.
Honestly, we have to tell you a lot.
I don't have the patience to go on one matter going on for months together every day, morning, evening, morning, evening. I have a different temperament of working. Either you condense your time schedule, and Diwan can do it. I know it.
Oh, I'll do it, but I want to start before 3 o'clock on the final.
That's all right, but the question is, must also.
Allow me to start. I will go at a rattling pace.
You may.
I can say, for Diwan, I can say, he has that much of.
No doubt about it, Malas. No doubt about it. Malas, we are a little slow.
He had done certain matters, he had the time to do.
Take a bit of time. We are a little slow.
Simple, if one matter goes on for a month.
Malas, this is affect every intermediary in the country, including the government, and it has huge ramifications. Please appreciate that.
Sorry, I just interrupted.
That ramification doesn't. Time should be there.
No, the time will be because we'll have to explain things. Malas, we have taken hours and hours and hours to understand ourselves.
They're concise constitutional.
I don't know what there is.
Lord, may I just mention one thing for Meta? Lord, this matter first came up, it was referred to Sri Krishna Committee and referred to Joint Parliamentary Committee. The first bill came. There were no less than 80 hearings, 80 hearings before the Parliamentary Committee, 80. And now they come with a bill. So it's not an easy matter. Because thinking of WhatsApp, what about so many other things? And
How many council are there on the respondent side?
I'm appearing for Meta, he's for WhatsApp. Mukul Rohgi is there.
Oh.
I'm also there for Meta.
There are 5 respondents.
He's there for Twitter. This will take time, Malas. This is not something that can be finished like that. And in between, we have other problems which I have shown
So
you.
the reason why we're saying it's complicated, not that we want to avoid the hearing. I'm saying that the matter is fraught with great difficulty. He wants to go to Europe. He wants to do those things. We have to refer to all that. And
it's a first level determination.
And at the very threshold, huge issues of maintainability come. As Mr. CapilSibal repeatedly said and Mr. Rohgi said, where is the cause of action?
I mean, don't forget that.
No. The Constitution has to have a cause of action.
Well, this is really,
After hearing that.
this is really a sui generis hearing.
That we can't be saying it.
No.
Only because we are both retiring.
No, but
Otherwise, we would have started.
Well,
like
this is,
No,
this is
the matter came on Delhi High Court.
Mr. Diwan wants to start, there is no other reason to start.
Pardon?
Except that Mr. Diwan is very desirous of starting, there is no imminent necessity to start. That I would.
key questions. No, correct. They are key questions which are being addressed by Parliament. Yes.
We have been assigned this task of hearing it and disposing. You can't say the one is starting it because.
Well, it's like.
Supposed to.
That's not the point, Mother.
That's not the point. Your Lordship knows what I say.
So the one is ready or you're ready. We are supposed to.
Correct, Mother. But we are telling your Lordships are difficulties.
And Lordship knows, but we have had earlier matters also invariably they spill over. That's the only problem.
This is not something that
the logistic difficulty was not there, but then there was no problem. So we'll try our best. That's what I'm saying.
Diwan, I'll take the responsibility of saying on behalf of the bench, despite the fact that I detest it. I would have rather preferred to start. I agree with you. But look at the whole of it together. Where are we reaching? Finally, this is not a simple matter. We definitely think that, it will have spillover various issues. And the council should not be heard say that they were not given time, which is what they will finally come and say. Apart from, the fact that the bill is there, this is our problem. Not that you should understand that we are ready to go right now before 3, which you spoke of, you would have started. But then finally, what is it going to come? They will not cooperate. We can see where they are going. They'll come and say on that day they are caught up in that.
Sorry, Manoj.
Well, that's not happening.
We are
saying that.
No, but this is
not. You should not have said that. When you are before this bench, you should have said you will cooperate. And not put up the.
You start then, Manoj. It's all right.
No.
We'll not appear in the other court. What else can we say?
No, we'll not hear it.
All right.
All right. Now let's just let me just indicate a point. There is your Lordships have spoken, so I don't want to now address you on that. Please take up IA 6140 of 2021.
Yes.
6140 of 2021. The paper book is before you.
Yes.
Now please go directly to page 40. And I'll just state my point, and then your Lordship may consider passing an appropriate order if you think it appropriate.
Yeah.
Now, this is an interlocutory application which we took out.
Yeah.
Let me just indicate a very brief background. The policy which is assailed in the writ petition in the Delhi High Court, and now before your Lordship, the original policy assailed is a 2016 policy. But the policy undergoes revisions from time to time.
21, we have the 21.
And there is now a 2021 policy, which we have also in turn placed on record, assailed, etc., etc. Now, what we are placing before you and what I am pressing now before the Constitution bench at an interlocutory stage are the prayers at page 40. So I'll just first place them and then I'll go on. 1. Stay the operation of the new privacy policy and terms of service dated.
Where are you reading?
Page 40. Para 83.
Yeah. Yeah.
1. Stay the operation of the new privacy policy and the terms of service dated 4th January 2021 of WhatsApp, and direct that the date of coming into force of the new privacy policy and terms of service dated 8th February 21 shall be deemed to have been extended pending adjudication of the present special leave petition. Just allow me to read it and then I'll explain each prayer. 2. Direct that without prejudice to the rights and contentions of the petitioners, WhatsApp shall not apply lower privacy standards for Indian users, and WhatsApp shall apply the same privacy policy and terms of use for Indian users as is being applied for users in the European region. And 3. Direct WhatsApp to give the following undertaking to this honorable court with respect to Indian users. Till such time that a data protection legislation comes into force in India, 1. WhatsApp shall not transfer or use any user data or information of Indian WhatsApp users with Facebook, any other Facebook company, or any third party for any purpose. And 2, WhatsApp shall not bring into force its new privacy policy dated 4th January 2021 for Indian users. Upon such data protection legislation coming into force, WhatsApp shall be at liberty to approach this court for modification or variation of the undertaking. And 4, direct the Ministry of Electronics and Information Technology, Government of India, to issue necessary orders to WhatsApp to implement its new privacy policy and new terms of use for Indian users from 8 February 2021, and to take necessary steps to ensure compliance with such orders till further orders are made by this Honorable Court. Now, just let me summarize what is here and what the current position is. The original policy, not policy as in the privacy policy, the company's business policy was either you use WhatsApp, either you adhere to this new policy of ours, or we are discontinuing you from using WhatsApp. That was their original position. And then messages were sent to WhatsApp users saying agree, agree, agree to the new or opt out. On that element, there has been a change. What is the change? They have said that we are not going to throw you out if you don't adhere to it. However, they keep sending a message to those who haven't adhered to the new WhatsApp policy, and a reminder pops up every time you open WhatsApp, or almost on a daily or weekly basis. On a daily basis, that please agree, 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 agree. So they haven't discontinued it, but they have brought in the WhatsApp policy. So now I'm making 2 points. The first point with broad points, and then I'll come into the details. The first broad point I'm making is that WhatsApp found itself in a similar situation with regard to the general data protection regulations of Europe, GDPR. So the situation they found in GDPR was that GDPR was on the anvil, or GDPR had come, but it came into force after, say, for a term of 2 years, because companies were given that lead period. At that point of time, they gave an undertaking even before GDPR had come into force, and they said that we will not prejudice in terms of sharing WhatsApp data with with Facebook. So please keep that in mind. So that is one request that I am making, because this is in terms of their European policy, they have expressly said so. They are not saying so insofar as India is concerned. So if they want the advantage of, let us have the advantage of a new act, etc., which comes into force, until that act comes into force, in our respectful submission, they ought to give such an undertaking, or the government of India takes appropriate steps and requires them to ensure that there is no such data transfer. That's first point. I'll develop it. Second point which I want to make is that the government of India itself has filed affidavits in challenges to the 2021 policy, and said that this is a sleight of hand which you are taking against WhatsApp, and saying that the manner in which you are imposing this and telling users that either you drop out or you adhere is completely impermissible and violates the right to privacy. That's the government of India stand on affidavit in certain challenges which are pending. That's the second point. The third point which I will make is, I will take you through some of the clauses which are there insofar as the European requirement is concerned, and which are not there insofar as India is concerned. So on these 3 planks, I'm going to make a request for these prayers. Now, please go immediately in this same application to page 23. Page 23. Now, here I'm going to just very quickly.
Have they filed the counter in this actually?
Yes, they filed it after notice. Correct. So I just quickly now indicate what they are telling European users. So I'll read it out from their own 2021 policy, which is absent in the India policy. I believe all of this is helpful, is wholesome and desirable, and ought to be the subject matter of the interlocutory order until whatever the Constitution bench then considers the case. Now, at paragraph 23. Please see para 66. It's extremely significant to note that several crucial parts of the new privacy policy applicable to European regions, which puts European WhatsApp users to notice regarding the amount of data information being collected by WhatsApp, the purpose for which the data information will be used, and giving the obvious option to WhatsApp users for access to, rectification of, erasure of, and objects to certain processing of their data is entirely missing from the new privacy policy applicable in India. For instance, some of the clauses which are present in the new privacy policy for European users and which are completely missing from the new privacy policy applicable to Indian users are reproduced as under. Please just let me read this quickly, the italicized portion. Legal basis for processing data is not provided. Under applicable, so this is, my lords, the European policy. Under applicable data protection law, companies must have a legal basis to process data. We rely on different legal bases to process the data for various purposes described in the privacy policy. As explained below, depending on the circumstances, we may rely on different legal bases when processing your data for the same purpose. For each legal basis below, we describe the purposes of our processing, why we process your information, and our processing operations, how we process your data. Example, we collect information from you and use it to create your account. We also list the categories of your data that we process for each purpose. You also have particular rights available to you depending on which legal basis we use, and we've explained these below. You should know that no matter what legal basis apply, you always have the right to request access to, rectification of, and erasure of your data. To exercise your rights, see the how you exercise your rights section below. We collect, use, and share information described in the information we collect section as necessary to operate and provide the messaging service and communication service described in our services section. Where applicable, including where consent is legally required, if you have given your consent, which you can revoke at any time, learn more here. As necessary to comply with legal obligations, such as when we are required to respond to a legal request from law enforcement, learn more here. When and as necessary to protect your vital interests or those of others, such as in the event of an emergency where there is a threat to your life or someone else's, as necessary from our or others' legitimate interests, including our interest in providing an innovative, relevant, safe, and profitable service to our users and partners, unless those interests are overridden by your interests of fundamental rights and freedoms that require protection of personal data, for example, to prevent our services being used for harmful and illegal activity. Where it is necessary in the public interest, learn more here. You may learn more about the ways and purposes for which we process the data and our legal basis for doing so. How the processing of the information takes place is not provided in the non-European policy. Provision of the services in accordance with terms. We process the data we have about you as described in the information we collect section as necessary to perform our contract with you, the terms. The categories of data we process will depend upon the data you choose to provide and the manner in which you use our service, which determines the information we collect automatically. The processing purpose is necessary to provide our contractual services are why and how we process your data. To operate, provide, improve, customize, and support our services as described in our services section of our terms, which include providing ways for you to connect and communicate with other WhatsApp users, including businesses. This includes collecting information from you to create a WhatsApp account, connecting you with businesses reachable via WhatsApp, analyzing your use of your services. Next bullet point. We use messaging metadata for the transmission of the communication, the operation of the services, including general traffic management and the prevention, detection, investigation, and remediation of failures, and for billing where applicable. Next bullet point, to ensure the safety, security, and integrity of our services. Next bullet point, we use messaging metadata to ensure the safety and security of our services, which includes their availability, authenticity, integrity, and confidentiality, and in particular, the prevention, detection, investigation, and remediation of security incidents, vulnerabilities, malware, and factors which could negatively affect the availability of services such as spam and even unauthorized access to use of services or user devices. Now, on the next page, your lordships will see to transmit to store and process your data in third countries, including the United States and other countries or territories as explained under. Data category use. We use information described in the information you provide, automatically collected information and third-party information sections of this privacy for this purpose. To communicate with you the services related issues, data category is used. Yes, we use information described in the information you provide. Now, none of this is there in the India policy. All of this there in the European policy, including your consent.
Go to page 28.
Page 28. Yes.
They say that we rely on our legitimate interests.
Yes.
Or the legitimate interests of the third parties.
Yes.
Where they are not outweighed by your interests.
Yes.
Or fundamental rights and freedoms.
Correct.
And then they say that.
Right.
Then over the page at page 29.
Yeah.
They say to share information with the Facebook companies.
Yes. To share information with Facebook companies to promote safety and security and integrity. Yes. See how we work with other Facebook companies for more information. Legitimate interest relied on to secure systems and fight spam, threat, abuse or infringement activities and promote safety and security. No problem with this at all.
Yeah,
yes.
What they have.
And
then how you exercise your rights at page 30.
Absolutely. How you exercise your rights?
You have a right to erase.
Yes.
Right to access, rectify, erase your information.
Yes, as well as the right to restrict and object to certain processing of your information. This includes the right to object to our processing of your information for direct marketing and the right to object to your processing of your information where we are performing a task in the public interest or pursuing our legitimate interests to those of third parties. We will consider several factors, etc. So this is there in the European policy, all these particular safeguards. Now please go in the same, as far as the same volume is concerned. So please just have a look at a couple of documents here. Please
what is the policy as far as India is concerned?
Yes, now this is absent. So in a manner of speaking, what we have said is that all of this is absent from the India policy.
Where is India policy?
Volume 10 of the committee.
You're talking about India policy. Where?
It's in volume 10.
There?
Yeah. Page 43. Same IA.
What's that?
Page.
The same idea they are saying 46. In the same idea.
If Your Lordship has page 43,
yeah.
P1.
Yeah.
So this is last modified for January 4, 2021, WhatsApp privacy policy. If you live in the European region, WhatsApp Ireland Limited provides the services under these terms of conditions. That's the link. And then if you live outside the European region, WhatsApp LLC provides our services to you under the terms and services of the privacy policy. So this is the latter one which is applied to us. Now, just on the Facebook point, which Your Lordship asked, in the India context, please go to the foot of page 51. Towards the bottom, how we work with other Facebook companies. Your Lordships have that.
Yeah.
And this
As
is
part of
this is applicable from A2. This is applicable from A2 2021. This
Yes. No, this was from 8 to 21.
2021.
So let me just indicate there are two elements over here. The first is that the 2021 policy comes in from 8th of February 2021 and then certain extended dates. Your Lordship is right. The problem which we have with Facebook, I should indicate, was also present in 2016 onwards. It was present in 2016 onwards, but this is their latest iteration. So please see bottom of 51. How we work with other Facebook companies. As part of Facebook companies, WhatsApp receives information from and shares information with other Facebook companies. We may use the information we receive from them and they may use the information we share with them to help operate, provide, improve, understand, customize, support and make our services and their offerings, including Facebook company products. This includes helping improve the infrastructure and delivery systems, understanding how our services and theirs are used, promoting safety, security, integrity across the Facebook company products. Example, securing systems and fighting spam, threats, abuse, and infringement activities, improving their services and your experience using them, such as making suggestions for you.
If your friend permits, this is going to take us to the entire matter and dealing with it. Then you might as well. If this is what's going to happen, Malaz. He's saying that you apply the European standard, Malaz, when the government of India itself is not applying. And he wants a constitution bench to, Malaz, apply the European standards. That's deciding the policy. If this is what he wants, then let him argue the matter, Malaz.
It will take a lot of time for interim.
There's no point. It's the same time.
Traversing similar distance, spending a lot of time.
I don't understand, Malaz.
Let him not argue.
This is the main matter.
We will adjust one bill.
Just the middle of the road. Are you prepared to give some kind of undertaking as to
No.
where you are prepared to go?
But we can't for India alone, bro. We got Europe and
we cannot give
140 countries.
Please understand, bro. We've
We
got
can't give any, there's no question.
140 countries. We can't change the policy for India.
We discussed
And
it
now
in
he's saying you apply the European standard. That's not even the government of India's stand. And that's the final relief. So the Constitution bench in an interim matter is going to give a final relief.
More time on this.
Unnecessary.
Short of the European model which you are advocating, is there something which we can plug in so that the bare minimum which we can?
Malaz, we have already
So
made a
what we are saying
statement.
is,
Hold on.
What are they prepared to
Malaz,
do?
what has already been, we have already told the government of India in a letter
Manoj.
to the ministry on May 22, 2021.
Let us see that.
We give the letters.
We just give the
You
letter.
see that?
Just let's read it.
Let us see what.
Yeah.
That's the concession point.
One point is Mr. Sibal's statement this morning that WhatsApp users' data will not be shared with Facebook.
You are
companies.
absolutely wrong. I made a statement to the effect that there will be no ads on WhatsApp. Basic.
That is not.
I don't know. My learned friend, Malaz, I think the people around the country have already heard this in the morning, Malaz.
So that let's clarify that. Yes, let's see this.
See the next page, last page.
Let us see what works. We are at 3:20 now, so that also.
We don't see the second page.
See the second page, the first paragraph.
Second page.
Second page at the back.
Summarizes.
So it will summarize.
We take seriously the feedback we have received from your agency and want to confirm, that's mighty, Ministry of Electronics, that WhatsApp will not limit the functionality of how WhatsApp works in the coming weeks as previously planned. We will continue to display our update from time to time to people who have not yet accepted. In addition, we will display the update whenever a user chooses relevant optional features, like when a user communicates with a business receiving support from Facebook. We hope this approach reinforces the choice that people have in how they use WhatsApp, which was our intent from the beginning with this update. We will maintain this approach at least until the forthcoming personal data protection bill comes into effect.
In other words, in other words, if you don't agree to our policy, you would go out of the system.
We don't want that to happen.
But we have not removed them from the system.
Even one person.
Even one person by saying that till the PDP bill comes, below,
we will continue.
The position will be maintained. Otherwise,
right.
For the last 1 or 1.5 years, they would have been out of the system without use of WhatsApp.
We've not done that.
We haven't done that.
And the government has not proceeded against us. Mother. The government has agreed to this. Otherwise, under the policy, would have thrown them out.
So
But
just
we haven't.
see the government.
Now he says, no.
This letter.
This was prior. This letter is prior. There is no reply to this letter. This is also wrong.
So this now, in response to this, after this letter of 22nd May 2021, the government has filed an affidavit in a case called Dr. Seema Singh and others versus Union of India. So please see, after considering this letter at page 12, what the government of India says, that it is humbly submitted that WhatsApp, your Lordship may just see that affidavit. This is an affidavit after this 22nd May 2021 letter. Sorry?
Where is the government of India?
The government of India is here.
So, I'm here.
Oh, you're there.
Yeah. Now see their stand.
Very much here. I'm very much here.
Yeah.
The attorney is here. The government of India is not here.
That in response to the aforesaid communication of 18th para page 12, that in response to the aforesaid communication dated 18th May 21, WhatsApp submitted its response dated 22nd May 2021, enclosing its preliminary affidavit, which has already been filed before this Honorable Court. That's the High Court. Yeah. That it is humbly submitted that WhatsApp, being respondent number 2, is indulging in anti-user practices by obtaining trick consent from the users from its updated privacy policy. It is submitted that millions of WhatsApp existing users, those who have not accepted the updated 2021 policy, are being bombarded with notifications on an everyday basis. The privacy and security of their personal messages and calls does not change. This is the message which is reproduced, and they've given a screenshot. Now please see para 12. That it is submitted that respondent number 2 has unleashed its digital prowess to the unsuspecting existing users and would like to force them to accept the updated 2021 policy by flashing such notifications at regular intervals. The game plan is very clear. That is to transfer the entire existing user base committed to updated 2021 privacy policy before the Personal Data Protection Bill becomes the law. That it is humbly submitted that the current notification as being pushed by respondent number 2 on its users, whether existing or new, is against the very grain of prima facie opinion of the Constitution Commission of India's order dated 24th March 2021, that in view of the aforesaid factual matrix, it is prayed that, that during the pending adjudication, in the interest of justice, the following interim directions issued: to desist from the action of pushing notifications, to place on record the number of times such notifications as on date are being pushed on an everyday basis, and what is the conversion rate of the policy. Now, after this, when the matter is in the High Court, they told the High Court that the matter is pending before the Supreme Court, so that matter is not proceeding over there.
No. There have been 7 hearings. After that, there have been 7 hearings and no orders have been passed.
Devan,
yes,
what the government has said. Now, you may say that the common man may not understand the implications of this.
Yeah.
Correct. We indicate today in the order that this is a stand which has been held out by WhatsApp. This has been acted upon by the government of India. The bill is in whatever stage it is actually.
There's no bill today.
There's no bill as it, but so this will be given full publicity. That, which means what? What is the effect of this actually? What is it that they are holding out? They appear to hold out that they will not compel you in the manner that you will be forced to leave. You can continue with WhatsApp.
That's right.
Whatever is the agreement which you have already entered into, that will continue. I mean, obviously, we can't be saying that, you can renege on your contractual obligation. What you're complaining is about the 21 policy as per which the terms of that policy is being forced on you. On the pain of your being forced to leave WhatsApp.
Yes.
That they are not forcing you to do.
Yes.
We can direct that wide publicity will be given to it. Yes. All users, who are using it will be informed that you don't have to, you can continue. You don't have to actually give this consent, as it were, which would involve giving up your rights. Now, what is the meaning of that?
Okay, just go for a moment to page.
What will happen because of that?
Yes.
What will happen because of that is the previous regime, meaning thereby the contract which you have entered into, read with the extent rules, will apply. Which means
so whatever is to apply is, yeah.
What will apply will apply.
Yeah.
So that if contrary to the contractual obligation, if they do something which is also contrary to the rules, obviously action will, you can take action.
Let me just tell you, there are 2 points. I wish to make only 2 points. The first point I wish to make is that you have now seen, so there's nothing further to say, that there is a dramatic difference between the policy being applied in certain jurisdictions and the policy being applied in India. I have made that point over here. I have also flagged the issues that each one of these particular elements of consultation, right to object, consultation in the sense that you have an option to opt out, etc., are all wholesome and completely consistent with privacy rights. One. The second point I want to make is with reference to page 163. And this point is that they gave, when the GDPR was still in the anvil and had not come into force, The undertaking which they gave, the European regulators, was that look, we will not share our data with Facebook entity. That's very important for me. Now it's up for the court to make a call, but just go to page 163. This is their undertaking there. I've read out my prayer already. Please see para 17. In order to provide, page 163, in order to provide reassurance to public concerning any future sharing of data between WhatsApp and any company of the Facebook group on a controller to controller basis, WhatsApp Inc. and WhatsApp Ireland both give the following voluntary public commitment. A. WhatsApp will not transfer any WhatsApp EU user data, including the UK users, to any other Facebook company on a controller to controller basis for any purpose prior to the General Data Protection Regulation GDPR coming into force in 25th May 2018. WhatsApp will only commence the sharing of WhatsApp EU user data with any other Facebook company for safety and security purposes. Sorry.
EU means what?
European Union. So this was before European Union comes into force, the GDPR comes into force.
What have they given an undertaking?
They have given an undertaking that WhatsApp would not share data of WhatsApp users with Facebook, except for the security and other purposes, which are safety and security purposes. So what we are suggesting to the court, since it was mentioned that, look, we have still to have on the anvil, the act is to come, we'll have the advantage of a new law, etc., etc. Then surely, until the new law comes into force, just as in the case of European users, they said, we are not transferring data to Facebook and Facebook entities. So the question is, if you are awaiting, or if we are to await the whatever Parliament chooses to do, if it chooses to pass an act, surely this is necessary in the facts and circumstances. Why should they be encashing and commercially using WhatsApp data for their business model and their business profits at this stage? This is my request. We have placed that prayer. I'm very grateful.
Those two responses.
Just one second.
We'll have to
Just 2 minutes only. I have given a chart to your lordship.
2 minutes by the clock.
Then see the chart.
Be going on like this.
Mr. Diwan has covered. I wanted to show the European order is already shown that. Just see the chart I handed over before.
Now we have said we are not hearing the case.
Your lordship is not hearing the case.
So that we are
Just see this minute what is that.
Yeah.
See in this chart, we are given the bird's eye view of all the three policies.
2 minutes.
2012, my lord, there was no problem. 2016, already, my lord, they have taken an agreement in the standard form saying we'll share it with Facebook, but not with third-party entities. 2021, my lord, is all comprehensive. A whole host of metadata, my lord, set out in column 1 is shared. And under the policy, my lord, they say we are parting with to Facebook, and they will, my lord, market it also. That is, my lord, the grievance, which was the undertaking pending the bill in, my lord, England, given to a commissioner. They went and told the commissioner, pending the bill, we will follow this. So, my lord, what is the sanctity of this consent which has been given in an I agree? Because already under 16 it is given.
If the 2016 has been departed from in the 2021 privacy policy,
We have challenged 16 and 20.
you're already parties to the 2016 agreement. Let us take it.
Assume that they would have signed the I agree.
Number. Yeah. So, in terms of that, whatever will happen, we can't be
No,
proceeding.
there they had a 30-day opt-out from sharing of data, my lord.
That's a matter which we'll have to decide.
That opt-out, my lord, should be given.
So now we've come to the 21 policy.
Yes.
Now, as far as the 21 policy is concerned, this is a public investigation. Correct?
It is a.
We take it, it's a public investigation.
Yes. Just to
If it is not a public investigation, then we can only say it's applicable to the.
No, my lord, it is. I am Internet Freedom Federation. Our Learn Fund is an association, my lord.
That's right.
Device
That's right. So let us understand what really is meant by all these documents and the law. You see, 2016 already entered into you agree. 2021 privacy policy, they are saying that if you don't agree, you can still continue. Otherwise, they could have snapped you off. You would not be using it.
Yes.
Number one. Number two.
In 2016.
Listen, please listen. Therefore, as far as the transfer of policy or making use of the policy in terms of the new privacy policy of 2021 is concerned, those who have not actually signed the agreement,
or opted out of 60.
Yeah, that's right. No, same thing. 21. We are talking about 21.
21, but that has to have two categories.
That's right. Let us
Yes.
the first category. Those who have not signed the 21 policy, they will not be bound by the privacy terms. Which means what? Which means if they act contrary to the 21 privacy policy, which means that they're taking away your rights under the law, which means the rules and the act. The bill is something we need not consider. Then you will have a right of action under the rules. I mean, like you can invoke the provisions and take compensation under 43A or whatever it is. That 72. 73A or 43A.
72A.
72A is the enabling provision for sensitive personal information.
So therefore,
No. 72A.
What is the undertaking? We'll put it to them in terms of the undertaking, whether they are prepared to give that undertaking. That's a different matter. If they are prepared to do that, well and good. That will bring
May I make a short?
put them they'll have a better image.
May I make a short?
1 second. 2016 will not also had an opt-out clause for 30 days.
So just a crossover to you. You are
May I just
operating
make-
600 million
Yes.
customers as well.
Yes.
So
But how many have complained, Mala? Just
no,
a,
through that, are you prepared to treat the Indian people on par with the Europeans?
That's the government to decide. I'm sorry to say.
So
I'm sorry.
evidently you're sitting here, you're not saying anything.
Malaj, I'm sorry. Malaj, that's the bill that is before you does not adopt the European standards.
That's right.
Does not adopt.
Deliberately.
So, Malaj, deliberately, number one.
What is the difficulty in actually
Malaj, the difficulty is,
treating Indians similarly to?
no, because there is a, Malaj,
I'm the holding company.
Malaj, there is 140 countries, Malaj, so therefore India must be treated with Europe and not with the other 139 countries. Then who is to decide that, Malaj?
But in terms of consumers,
Consumers also in all those 139 countries, Malaj, are accepting this.
What is the economics? Is it
Yes.
is a matter which goes to economics?
No, we can also show the European user suffers drastically. We'll show that also.
Yes, Malaj, yes.
European user suffers. We got the chart on that.
Their services are very poor and much less
much
than
poor.
what we give. But be that as it may, Malaj.
That's why US doesn't have it. Singapore doesn't
Therefore,
have it.
Malaj, this is the final relief that they are asking for in the main petition.
We are aware of.
That's right. Then number
The
two,
question is whether you are prepared to give it.
Malaj, I've said that we will not cancel them. Malaj. They are on WhatsApp. They continue to use WhatsApp. They are not forced to accept the policy till the PDP bill comes. If the PDP bill comes, we are bound by it. And in England, Malaj, there was a law already, a protection law already, data protection law already.
And what is the sharing of data with, what is it that you?
Malaj, as I said to your lordships, there is what is called a business app. Business app which came into force in 2018. Whereas this was not there in 2016.
Okay.
So they want to take advantage of the business app and then say that you should not share anything with Facebook if they are both on Facebook and WhatsApp.
So it is only shared in the context of the business app.
That's right. Yes. Otherwise,
Excellent. Let that be recorded.
1 second.
Let that be recorded.
Please understand. Otherwise, only the basic subscriber information is shared. Malaj.
So those who use the business app.
Malaj,
Can I
Let us understand what.
Malaj, let's be clear on it. Malaj.
What is it that?
Malaj, it is better, I would suggest, Malaj, we take back whatever we said. Please argue the matter because this can't be decided in this matter.
No. What is the difficulty?
Malaj, we will take 2 hours to explain this, Malaj.
Can I just say?
Let's start the. What we're asking you is, unless you refuse to share with us, we'd like to ask you.
Yes.
What is it that you are sharing with?
We'll have a presentation. We'll show it to your lordship.
We've got a presentation.
Can I just something that I can answer in 1 second? Yes.
But I'm the holding company, Lord. So I have Meta, which is the former Facebook. We have got WhatsApp. We have got Instagram. We have got Facebook. So we're all subsidiaries. Now I want to clarify this. The leitmotif or the undercurrent of the petitioner stand is don't treat India differently from you're treating the Europeans. That is the fundamental point. Again and again we'll be arguing, and that's the core of the issue. What happened in Europe was well before what is GDPR? General Data Protection Regulations. The General Data Protection Regulations are framed under the Data Protection Act. There was a Data Protection Act. The Data Protection Regulations were in debate because it's 27 countries in the EU. You have to get consensus. So it took 5 or 6 years to get it. In the meantime, WhatsApp gave some undertaking. Now, what we found is this actually reduces the efficiency of WhatsApp is our stand. We'll do it. So my submission is what was basically put to Europe was put to a parliamentary committee. They asked us, why can't you treat India like Europe? That's part of the parliamentary discussion. Yeah. And in the memorandum, they say we have considered the experience in Australia, Netherlands, Europe, and this. After considering all these countries, the provisions similar to the GDPR are not there in the bill because it is not possible. Now, therefore, my submission is, if it's a privacy issue, I'm sure my lord, 400 million Americans are not going to sleep. They got enough more hyperactive NGOs there also. It's not that only we are here.
Billions of Indians there.
Millions now. Yes. Now my submission is US, now UK because UK is out of the EU, Singapore, Australia, all these developed countries, entire Africa, entire South America, all have got the same thing except Europe. So barring 27 countries, the remaining all the 150, 200 countries all have got one single model, which is the model we follow in India. Now, Lordship asked, what is WhatsApp business? How it is done? Lord, what has happened is, I'll explain if my friends can correct me. Lord, these people, I'm sorry, the petitioner do not understand what they are asking for. Today, my lord, WhatsApp business is used by small kirana shops, used by small shirt manufacturers. Now, I'll give you an example of what WhatsApp business does. I want to purchase, let's say, an Alan Solly shirt or an Arrow shirt. Now, WhatsApp business is now the Alan Solly shop will be a WhatsApp business account. I go to their WhatsApp business account and there's a facility where I can go and choose the shirt I want, etc. There is a Google Pay or WhatsApp Pay and so on. Now, when I purchase the share, the transaction will be recorded by Alan Solly. He may take place on the Facebook server. He may take place on some other Amazon cloud server, whatever it may be. Now, as far as I am concerned, even though I buy an Alan Solly shirt, I'm never going to get bombarded with advertisements. But once I am in a WhatsApp business, the fact that I bought a shirt involves a third party and that data will be stored. Suppose I book an Air India ticket, it will be stored on Air India server by the third party. That's why Mr. Rodgi and I said we both don't have any Facebook account, we don't have anything. So as far as my account is concerned, I'm not on WhatsApp business. I don't buy anything on WhatsApp. My messages are end-to-end encrypted.
WhatsApp business is a separate
about the metadata.
Yes, no, right. The entire metadata was in regulation 27 of Aadhaar. Yeah. Metadata is analyzing the data of the data. Metadata, like metaphysics, is a physics. So as far as metadata is concerned, we have got very, very clear instructions. Now, say for example, I've bought an Alan Solly shirt. Let's go and say, this is Bose asks, on Facebook I purchase shirts. I buy Alan Solly shirt. It may happen that Facebook advertiser may get a van user advertisement because he has sold it. The artificial intelligence which is there in all the apps, not just WhatsApp and Facebook, every single app, ICR, like you take Make My Trip or you take Google. I just Googled one thing of how to see the Nile cruise. I got bombarded with Google. What are the options of hotels and then what are the Nile cruise available? What are the airlines to Egypt?
And WhatsApp doesn't do that.
Yes, all that is done because the system picks it up. And please see, since I've asked for Egypt, they don't tell me how to go to Colombia or they go to Venezuela. This is how the user experience is enhanced because they know what are the preferences of this person and the advertisement goes to them. I'm talking of Google and other apps. Now, as far as the main petition is WhatsApp, again and again they say WhatsApp should not share WhatsApp. WhatsApp on pure end-to-end does not share any message or any violation of privacy. And what is privacy? Personal privacy, information privacy, autonomy. Nothing, none of the Puttaswamy are violated.
That is why they have not shared anything with your lordship. This is what has been shared.
What does WhatsApp share?
Exactly. We don't share anything except for the basic service information. But as far as I'm concerned and Mr. Rodgi is concerned, our information is not close to anybody.
Phone number really.
Only phone number.
It's a phone number.
Yes, and I'll tell Lordship why. There is also, and the WhatsApp has got a facility of auto delete. You can delete your messages.
There is something we share. We can show the purpose of sharing. It has nothing to do for the purpose
privacy and advertising.
And we'll satisfy your lordship. You'll have to hear.
This WhatsApp business is separate from the WhatsApp which your lordship might be using.
Yes,
if your lordship takes WhatsApp,
business messaging
normal
app.
WhatsApp, there is a WhatsApp business
messaging app.
That's a separate app.
If you don't want to be there, you'll get none of this. If you don't want to be on the WhatsApp business messaging app, you'll not get any information.
2021.
But if you want to be there, you say you want to be there, but at the same time, some data which they have collected, third party has collected, they should not share. How will that be possible, Mother?
Under the 2021.
Everything will fall apart.
And the whole difficulty is now WhatsApp has got arrangements with numerous
Can under the 2021 policy share its data with all Facebook companies.
No. What data?
That's the clause in the 2021.
Share us what data we are sharing.
I'm sorry.
Have you signed that agreement?
I'll tell your lordship about that. Those are, that's one issue, of course.
So that's the first issue.
Yes.
Have you signed
The first issue is as far as,
So they have said, though,
yes.
though you have not signed it, they are not going to sign
Yeah,
you
your
off.
lordship is right. If someone has not signed it, they are not troubled. But what's going on instead? Every day, and this is a specific.
You're being bombarded.
No, and this is a specific practice recognized also by the European Union as a practice deleterious to privacy, which are called dark patterns, where a pop-up comes up, dark patterns, where a pop-up comes up every day, and a user's preference is ultimately controlled by his need to get rid of that irritant.
Once a month.
This is I accept finally. You may say no 10 times. You may say no 15 times. On the 20th day, most users will end up saying, I accept. That's a dark pattern. It's well known.
Supposing they say that why publicity will be given.
Coupled with, please tell us how WhatsApp, how many times WhatsApp has done it. We don't do it. It's wrong.
Every day,
Please tell to show it. Put it on affidavit.
Publicity. We will today order.
Yes. Nothing on it.
Nothing.
Notice stand taken by WhatsApp.
Yes.
The communication with Government of India. We will notice. We stand by that, and we will say that's why publicity will be given by the Government of India in every which way, so that those who are interested in this are informed that they need not be troubled.
One more after the publicity, even to those who accepted, when they had no publicity, then an option be given to access. It's a very reasonable request.
Because ultimately, our claim is.
Mr. Vishwanath and something.
We'll pass the order right now, if you want us.
Get the publicity is a welcome option, welcome that.
That's what we
But
thought.
that the benefit of that publicity
Whether we
give to those who accepted without the publicity.
It is the aspect which is precisely that. Your lordship is.
Another thing, curious thing we want, like we are striking us as people. Actually, what is the loss that is cost to you?
Yes.
Just before we explain what's troubling us. You're getting to use this WhatsApp.
Yes.
You don't pay a single pipe for that as such.
For international calls.
You don't pay anything, I guess. Except for the use of the internet charges.
Even for international calls, also.
Yes, free. Video call, all free.
And we all believe in these systems.
Yes.
Can I answer this?
Group calls, everything.
We'd like to know
Yes.
why you're
Yes.
using it on the basis of the payment internet charges.
Yes.
Apart from that, you don't make any payment.
Your lordship is right. Monetarily, it seems that there's no
Seems
cost.
Yeah,
Your
then
lordship
let
is
us,
right.
because now we are considering
Yes.
an interim matter.
Yes.
So
But-
they are not yet reached a final conclusion
I understand.
because of reasons.
Because your lordship
There
is
we
troubled by
have
that
to
question.
balance it. That's why we evolved this kind of a relief. We thought we could.
Lordship is troubled by that question. What is the loss cost to you? The so one is there a monetary loss cost to you? Obviously, you're not paying money, so there's no monetary loss cost to you. The second aspect is there a privacy loss cost to you?
That's right.
That's the second aspect. So now there is a well-recognized, what Mr. Diwan referred to as surveillance capitalism. There is a well-recognized idea that the cost of all these apps is a privacy loss. That's the cost. That's the constitutional question facing it.
Monetary value to it also. You can end up finally by putting a monetary value to it.
Yes.
But not
They
everything.
monetize it.
This is what we call in,
When your lordship sees the 2021 policy, forget about the issue of who has consented, who has not. Why is that policy then? Why do they say we can share all this data with other Facebook companies? Who are these other Facebook companies?
They out here to do charity.
No, they're not.
They're
But
not.
then they should do it transparently.
Do you want a gift
No.
thrust down your throat?
But if they are saying, now,
Still, after you accept a gift,
yes.
actually it's a gift.
Your lordship, let's look at the lay of the land here for a moment.
onerous gift.
What happened in COVID?
Transfer of property.
What happened in COVID?
Because the predatory.
This country has
They
the
are
largest.
not brushing aside your point.
But let
You are
me,
making these observations only in the context of an IA.
yes.
In a matter where you have to actually climb the summit of the mountain.
Yes.
Yeah, and say probably.
We're at the base camp.
Base camp, somewhere the other base camps. You have to mount so many.
But it is important to understand this issue because
That's the
this
final
narrative
relief.
that is being given that you're getting something for free. Number
Yeah,
one, you're not.
see, we have heard right from 10:30. So what is the objectionable data which was transferred?
That's right. He doesn't mention it.
For the past 3 hours or thereabouts, we have been hearing it. Please tell us.
Bro, nothing in the affidavit, not a single affidavit mentioned.
Not a single affidavit, not a single
We want to know.
piece of information that this is what has been shared.
You have been saying that, then what is
No evidence.
at least one? What is it? Only to understand. Only to
As an
understand.
example, as one example, WhatsApp's own policy says your location information can be shared with the Facebook companies. It says so, as one example. Now, what are the Facebook companies?
You can turn off location.
Instagram.
It's simple.
No, I can't. I don't have an option. How I can turn off?
You don't share your location.
Nothing is being shared.
Bro, I don't interrupt
How I
my
can
friend.
turn it off?
Bro, I don't interrupt my friend. Page 4109.
Even
We
location.
do not share your location with someone on WhatsApp. Your location is protected end-to-end encryption. Let's not get into all this.
Website also says that even after you turn it
Your
off,
Lordship will have to hear this at length.
still be
I will have to.
That is one thing.
It can't be decided like
That's
that.
Everybody knows. Google.
Day in, day out, we are putting our location, live location on WhatsApp.
Uber.
And we share.
Yeah,
live location.
Yes.
Live location. We put it to facilitate ourselves. So the family should know where I am.
Yes, exactly. Yeah.
Now, tell us one thing. If you don't want it, you don't want to use this app. You don't want this live location to be shared. Live location.
They don't allow option.
This
Allow, don't
is
allow.
the crux. Your
You
Lordship
want
is
the
right.
facility to be availed.
Your Lordship has hit
At the same time, you want to say nothing to
Your
it.
Lordship says
And
it's a
why
question of
destroy
choice.
it? Go.
Your Lordship says it's a question of choice.
And why WhatsApp?
What
What is about Google, Manoj?
What are they saying? If I want WhatsApp to have my location, no problem.
WhatsApp actually from morning to evening.
I will give all my other companies a location.
Which
That a choice?
have you given?
Is that how consent is procured? That's the question before your Lordship.
Ultimately, boils down to me. If you are a very disciplined citizen, everything goes in the right direction.
To be a very educated citizen also. That's the point of privacy.
It's rather curious, Manoj, that 10:30 to now, it's only WhatsApp, WhatsApp and WhatsApp. Whether there are any number of intermediaries, there is no Manoj's argument with them. I wonder why this is happening.
I have petition is on all the intermediaries, but it's not been heard.
That's right. That's
No,
right.
no, petition is heard.
Sorry, my friend made a very important argument.
Refused to have it.
Lordship has to ask the question, why are they targeting only WhatsApp?
Exactly.
600 million users.
No, no, that's all.
Whereas Google and other platforms,
Has billion users. Email, Google.
Google.
I don't think, my lord, they should shoot on Google.
No, we are not shooting.
I have a separate hearing make and I will make
No,
it.
but-
Let WhatsApp defend itself.
No. We are only saying that why is it that the argument is concentrated only on
Tell
WhatsApp?
your Lordship.
The answer to the question of how which went for my thoughts is profiling.
Because we are the most secure app.
That's for bad. What they actually do is by collecting all this metadata from us, they end up profiling a person, a user of a Facebook, and then they influence choices. And
Which choices have been influenced of yours?
Cambridge Analytica collected all of this data, influenced it politically, in which 5 lakh Indian users' data was also shared.
that some material must be before us.
Yes.
It's all there. We have taken these pleadings, all those documents are.
Meetings is not material.
Cambridge Analytica was particular situation.
Exactly.
And not to do with WhatsApp. It has nothing to do with WhatsApp.
5 lakh Indian
Because
users.
now every other person are describing themselves as influencer.
That's
We
right.
have not understood the meaning.
I've been influenced to mean, suppose
The
you
Facebook admitted.
suppose you get so many viewers on a YouTube.
Technology.
But at your Lordship, suppose
That's
I'm
right.
doing a cookery class and I've got more than say 100,000 users, then I become an influencer. Then they will tell me to put this particular cook.
To cook.
No, you're in front of public opinion.
Whereas I'm on
I just is not right. Please allow me 2 minutes.
I am on Pinterest, Manoj. I'm just saying.
Just allow me 2 minutes.
I am on
I've
Pinterest.
spoken this
Manoj.
morning.
In Pinterest, I can access architecture. So, Manoj, and I access 2-3 times architecture. I get every day, Manoj, I get information on architecture. What's wrong with that?
I'll give 3 examples.
You become influencing. Who is the influencer?
The person, Manoj, the influencer is, but all of us are influencers. All of us.
No, as my friend said,
So
I tried to access Everest base camp.
What is the loss cost to?
Question of power.
What's the harm? Whereas harm is defined in the data bill itself. Harm is defined.
Please permit me for 2 minutes.
Bodily harm, distortion or theft of identity, harassment and provision of lawful gain or causation of
Submission belongs.
So none of this is covered. Harm is defined.
We are only considering the application now.
Yeah.
On that part,
There is nothing else to be done.
no,
Yes.
only on that part, make a responsible.
Council,
I am in a different matter, my lord.
no.
It's a 2 minutes.
Please understand
Yes, I have.
the spirit of
We are
what has been said.
all the applications.
That's right, just that bit.
So what we will do is we will refer to this communication. We will refer to the, stand taken. Now, one more thing, do you intend to, because you said that you are not doing it, because that you're bombarding them as you were saying.
Yes.
Are you saying that you are not bombarding the customer?
No, they are saying I'm doing it daily. No, Manas, I'm not doing it daily. On a periodic basis, I tell them, there's nothing wrong with that.
We'll do one. I know that. So what does the government of India say? So the attorney
Government of India has not, Manas, objected to this.
You're
The affidavit was read to you.
permitting the government of India to open up. Both of you are actually, between.
I'm only trying.
Your stand. Why are
I look at, I think I go by this general proposition.
Put the microphone in front of
As far as the interlocutory application is concerned, I don't think lordships will travel beyond the narrow domains of the application, and particularly when there are no factual matrix available for them to, now, number one. Number two, I've seen the reply given by the government of India to that letter. And it asks WhatsApp to undertake a certain course of action. And it's up to them to take a course of action. Suppose they don't do it, government of India will follow it up. That's all right.
It's no problem. But we had multiple discussions with ministry.
What is it that you have that you've asked them to do, and which if they don't do, you will follow it?
They have not.
They are happy with our plan.
What is it that they say? What does it? We say that you will follow it up.
Lord, may I just suggest your lordships?
That's all that we have.
May I just suggest your lordships can consider it?
No, you can't have it both ways.
No.
This is the government of India.
No, I'm just
That's
saying
fine.
that what we told the government of India pursuant to discussion was that page 2 paragraph, that is the undertaking we gave. It is continuing till today. The lordship indicated that will continue till the bill takes shape.
That's all.
And lordship wanted it to be publicized, so we publicized an English newspaper.
We publicized it.
Further order.
Until further.
Yeah.
Until further order. We make
Unless PDP bill. Until PDP bill. Until PDP bill comes.
Or lordship may say until further orders or till the act is
Say
passed.
PDP bill, because otherwise it will continue after the bill also.
That's better.
Or the bill comes.
Yes,
the
till the
bill
bill comes, absolutely.
No, bill comes.
Well, it's because the bill comes.
Enactment.
The enactment.
Yeah.
The
Enactment.
enactment
Until
happens.
further order.
That's right.
Till the enactment
If
happens.
enactment comes,
Your lordship gives liberty to make.
we'll see.
Liberty, don't say that.
Until further orders.
Well, the bill will override
On the law.
that, and we can't say
You don't
that.
know what the bill is going to look like and what is.
Whichever way it is, whichever way it is.
The bill is going to look like.
Well, that's whatever-
It's only because of the lack of.
No, but what will happen is, Mother, that this will
Now, the next
continue.
question is,
Yeah.
how do you give publicity to it?
We'll give it, Mother, the newspapers.
Given on
Who will do it?
We have put it on website already. We have given publicity. Otherwise, we'll give it also on newspaper.
On our website, it is there.
It is there already.
Website is not good enough. Who knows about your website?
But anybody who accesses it will go to the website. Mother.
But it should come in the visual media.
Visual media, Mother, why would your lordship?
The visual media, at least that you should do.
Mother, I don't know, Mother. I'd rather go to website than watch television nowadays, Mother.
Can I just?
That's a different matter.
Can I
Well,
just
that's-
suggest
I don't-
one option, Lord, is that too, which we do for other sale of large properties when like this Aramat, when properties all over India have to be sold, usual direction is one all India edition of any
Yes, sir.
paper, Lordship.
We are not going to permit you to do that alone. It can't be done on a single solitary basis. You have to do it at least 3, 4 times. Maybe once in a fortnight, then thereafter next fortnight. So
But as for what,
nobody will know about it. Nobody will know about it.
People will get confused on that.
Except that perhaps we are on national TV.
No, Mother, with greatest respect, Mother, with the greatest
Directions your
respect.
lordship may consider.
Yeah.
These push notifications that come, they don't have an option that says no. There's a cross.
It says, that's also wrong. It says.
Wrong.
It is wrong, Mother. I don't know why my learned friends are
Once the
making
user
some.
says no, it doesn't appear again.
What do you say?
But
Does it have that?
Yes, it
Yes, it does.
Then how will you get them?
How does it come every day? Then?
There is
Well, there is a cross there, Mother. You have to cross it, that's all.
Then it comes up again the next day.
I can
There
show
is an option of no. Once the no is pressed, it does not come up again. Why are users being directed?
But I don't understand why they are getting into these matters, Mother.
Because we are not getting into the case.
Let's go into the case. Go, I'm ready. Shall we do one thing? Yeah, okay, one thing. One edition, English edition. Because now, and we can say one vernacular paper.
Ideally, it would be in some channel. Even government of India can implement.
Not may I make a suggestion? We can send a message to the users who have not accepted on WhatsApp.
What will you say?
But giving the details of this communication, not saying that this is the situation, you can choose to accept not. That way, those users who have not accepted have specific information.
We'll have to take
And what's happening is those who have not opted, they know it because they get the pop-up every month. So they know that because what happened, almost 99% have accepted. Only this one group, few groups, they say we don't want to opt.
Not groups, individuals.
Individuals.
Yes, no groups.
What should we say out of 600 billion? Please find out 599.9.
How do you give the right publicity? Just tell us that.
No, I'll tell Lordship why.
Keeping in mind that the
No, I'll put it say those who have agreed to the new privacy policy, they are not concerned. Like I'm not concerned. I don't have any problem with the new privacy.
Even those who have agreed,
Yes.
they have agreed because they were just irritated or just forced to, as your lordship correctly observed. They should be given a choice as well. But anyway, now your lordships have passed.
One option is newspaper. Other option is to like we said that those who have said don't agree, who are still waiting on their wings for the judgment of the court, they can do that.
keeping in mind that most users are voice messages because they can't type. That publicity has to be meaningful.
What publicity?
It can't be a message saying we'll conform with some communication.
But who has complained? Who is you? You are just targeting WhatsApp. Yeah, you got some other agenda in mind.
Now that we have done. What days we are posting it? Because it cannot be now before.
The parliamentary session suppose gets over end of March. Lordship may post it sometime in the first week of April. Lordship will know the idea. Suppose the bill has gone through.
We'll know exactly the position.
So at least, before summer vacation, we'll know we have some clarity. That's my
Then
suggestion.
we will post it not for hearing, it's only for direction.
That's correct. Fair enough.
Otherwise, again, it will be,
Yes.
Muslims will come here and argue and
Fair
argue.
enough. Today at 2 o'clock also, Monday.
That's it, just for.
Compliance and direction.
April. Because the session gets over around the 10th of April.
No, I think it was the 3rd of April is what the Solicitor General.
1st of April will be the ideal day. For a case of, we have been going through
By
this.
that time, we would have crossed the Ides of March.
No, we'll really try 1st April.
1st of April is a Saturday.
So your lordship may put it on the 7th or the 8th after the parliamentary session is over.
Yes.
8 is Saturday.
10th.
10th
is fine.
No, 10th is a miscellaneous day. 11th. 11th, we'll put it at 3 p.m. 30 p.m.
Yeah.
No more than that.
10:30 a.m. Manoj, let us have it before the Constitution bench at 10:30
That's all
a.m.
right.
Then your lordships can disperse and do a full day's work.
10:30 a.m. for direction.
Can't really dispute on that.
Number 2, reasons for adjournment. Now you tell us finally that publicity, how you do it. So before I dictate, I should be told.
Newspaper and
What will you do it?
Print and visual media.
newspaper and
Who will do it?
WhatsApp will do it.
Company will do it, obviously.
But I will ask WhatsApp subsidiary to do it. WhatsApp will do it.
The profit you are making,
Print and visual media.
No, print is enough.
Print and visual media means what?
Print is national newspapers, they themselves say, including regional newspapers, and the channel.
How many
channel?
832 channel. What is happening?
Talking about.
Doordarshan, you can do it, but we don't know how many people watch.
What people will get
Please don't misunderstand it. There is a huge qualitative difference now. Doordarshan and that I.
Much better news. Much better news.
news.
No shouting.
That's a national
And the reach is great. It should be watched by more people. I watch Doordarshan News. Watched by more people.
Oh, yeah. I remember in Delhi 1970s, Doordarshan would start at 7 and
Rishi Darshan.
yeah.
That's right.
But we have come a long way. Please don't belittle that.
Reach is great. No, but honestly, it's the most balanced news.
Balanced.
Most balanced news. There's no agenda there.
Yes, that was personal.
But what I'm submitting is
What happened was in the first week of
The
January.
Doordarshan you can do it.
No.
Well, in
Government of India can do it.
January, we gave a front page ad in the newspaper.
give that
But
same
we
ad
give
again.
that same ad again because you were directed. Why? That's the best way to do it.
So and you will give it in which
All newspapers.
All newspapers.
All national.
All national newspapers.
No. Prominent. All in the sense.
Not all prominent national news, Times of India, Hindustan Times, Hindu, Indian Express. That's good enough.
Around 5.
That's good
You've
enough.
been doing it once.
Once.
Then what about visual media?
Visual media, mother, some people will see, some people may not see, mother. It's a
People, you know-
1 minute, it's a 1 minute news. We don't repeat this like news, mother. So the people, most millions will not even see it.
Repeat it. Why don't you repeat it?
But mother,
What is
How much does it cost you?
no, one full page ad
With
costs
cost,
4-5 crores all India.
what's the?
It's not the cost is not important. Information. Only one may say is one thing. We give a quarter page ad. We give a quarter page ad. Repeat it. If we'll give it every 1 week and repeat it after 15 days. That's enough. By the time April will come.
Same advertising.
Be on social media also, madam.
No,
There are
no,
companies that won't cost.
We are also on WhatsApp. We'll do that in WhatsApp itself.
WhatsApp will also certainly be done.
WhatsApp.
We are anyway sending.
We are doing it already on WhatsApp.
You're doing full page or
We will give a
We'll do quarter page twice. That's better. Instead of full
There
page,
is a
we'll use it.
website, there with a website where it is already there.
that you will, that's already there.
That's
Quarter page
right.
twice.
So that's done. Then newspaper, same advertisement in newspapers.
There is no option.
Yes.
When, you know, if you have a definite no option, you will not beguile somebody.
Not because that requires the technology changes.
Countries, but
That
this is
requires
the problem.
changing the technology. It's
Well,
difficult now. But
this year.
10th March, Lordship is putting on 10th April. What happens is I've got servers all over. I can't just change now because I've got same used in 140 countries. We can't change it just like that.
Like that at all.
It is like
Don't say so nice.
Not we give a cross like this because then even if you can't read, you can understand what a cross means. The status will continue.
Government government independently.
No, we will do it. Government is
Can do it, but government, Doordarshan can do it. Whoever watches Doordarshan.
not necessary.
If they opt for Doordarshan, we have no problem, but
You'll have a problem in doing it.
But may I say one thing, Lord? One quarter page ad in the national dailies, let's say on today's 1st February, on 15th February and again on the 1st March, two times. By the time the next 10th April hearing is coming. And that's enough English paper.
Let them do it in Doordarshan regional.
Yeah.
Since they're doing it in English.
Doordarshan regional.
Then
Doordarshan?
Regional Doordarshan. Every below language. There is a DD.
That you can do.
But I don't know which, because I Hindi, I think Dainik Bhaskar of Amar Ujala has got a lot of one Hindi paper.
Let the Doordarshan carry it.
Alright.
Government of India doesn't lose any money. I mean, it's nothing much.
Is the WhatsApp is the only entity which is you carry all this money? There are no other intermediaries which do the same thing, which will not carry. Well, this is not.
And everybody
Yes, what kind of signal are we sending, Malaz? That WhatsApp is the whole world, that WhatsApp is targeted, Malaz. Why for what?
Because we took up WhatsApp case.
But Malaz, this is the case is the PDP bill is not about WhatsApp, Malaz.
And others change their privacy policy also.
They are all Malaz gathered here only to target WhatsApp. But they have not talked about any other intermediary, Malaz.
EU law applies to other intermediaries.
EU law applies to all intermediaries. They have not said that. They have not said that.
What are you saying? That
It is coming out of envy. The subscriber base of WhatsApp is leading. Subscriber base of WhatsApp. I say it is generated from envy.
Google is also there, Malaz.
No, but WhatsApp is studying. Anyway, there are intermediaries. You are right, Mr. Sibal. There are several intermediaries, but why my name?
The information.
Malaz, why? Because they get service free from us and they don't get it from others.
All right. We are not asking an answer for.
Newspaper. When this matter was taken up.
Newspaper should be the
same advertisement.
The respondents, in particular the learned Council, Attorney General and the Solicitor General appearing on behalf of the Union of India, again brought a notice the fact that a bill,
Data protection.
a data protection, a bill,
Personal data protection bill.
digital, all the personal data.
It is Digital Personal Data Protection.
The Digital Personal Data Protection Bill 2022.
Personal
Data Protection Bill.
Data Protection Bill
2022.
is on the anvil of being
Placed before the Parliament.
placed before the Parliament. We don't know what that means. We are putting it to your mouth. Yes. Before the Parliament. It is their conviction that the bill it will be considered, and so don't say put in it. Bill would cover most of the would deal with all the aspects. Will deal with the aspects which are subject matter of the petitions before this court. And it is prayed that the case may not be taken up. This is totally. This request is also echoed by the London Senior Council for the respondent, CapilSibal. Who else is there? All of us. You are also taking shelter under that.
Mr. Rothgi.
No,
Mr. Rothgi.
Mr. Luthra.
Mr. Luthra.
Luthra also.
For Twitter alerts, I also Raju Ramachandran.
Raju Ramachandran also.
And not to forget Google.
Oh, I have. Yeah. London Council for Google. This is our stoutly contested by Sri Shyam Diwan and also Sri K.V. Viswanathan, London Senior Council. And also the other London Council appearing on, please take their names. They would point out that what is being touted as the reason for seeking an adjournment of a matter which stands posted in the Constitution bench is the prospect of a bill going through various stages and finally emerging as law. And such a request should not detain this court. The Shyam Diwan London Council for the Senior Council for the petitioner would point out that arguments would be addressed in a time-bound manner, and the petitioners would, on their side, conclude their arguments at the latest by the 9th of February. He would complain that whenever this matter was originally, when the matter was originally taken up in the year 2017, the very same excuse, the very same ground was trotted out for getting the matter adjourned. We are today in 2023, he points out. That apart, Sri Shyam Diwan also did take us through the merits. In that, he drew our attention to the fact that the stand taken by WhatsApp in particular in regard to its customers in Europe, it stands in stark contrast with the stand which is being taken in India, which is without any warrant. He prays that this matter may be heard very well. Noticing in particular the fact that two out of the judges hearing these matters are scheduled to retire in the month of June. We should say that. We should say that. Otherwise, we would have said it. Otherwise, what do you say? What reason do I give you don't want us to say that? Okay, don't say it. Because otherwise, we will noticing the fact that the bill is also being considered, and also it's unlikely that the arguments may not conclude. We have the view that the matter need not be considered immediately. Full stop at paragraph at this juncture, Sri Shyam Diwan would then press for interim orders being passed. And in what is the IA number?
6140
6140 6140 of 2021 in specially petition 804 of 2017. He took us to the IA way that the relief which is sought therein may be granted. The relief which is sought, the relief which are sought are as follows, set out that relief, and this is a separate paragraph.
Each one.
Page what? When this the Land Council for the respondent who pointed out this letter.
I pointed out, Modest Your Lordship, this letter.
Yes. Sri CapilSibal Land Council for the petitioner for WhatsApp, for appearing for WhatsApp, to point out letter dated 22/5/2021 addressed to the governmental authority. Therein, our attention is drawn to the following portion and take down extract this in. Yeah. The Land Council for the petitioners no doubt would press for an interim order to the effect that even those persons who may have agreed to the terms of privacy declared by WhatsApp, either in terms of the policy in the year 2016 or even in terms of the 21 terms of the privacy policy in 2021, should have the option of, what is it?
Opt out.
Should have the right to opt out.
Yeah.
Of data share.
This means, according to them, that while they should be permitted to use the WhatsApp, their agreement to allow the use of data should not stand in the way of their wriggling out of their obligation, under which WhatsApp would have the right to share the data. Paragraph. We would think that we may not be justified at this stage in granting the relief as sought for by the petitioner in EA 6140 of 2021. The matter may require consideration of the issues which arise. As things stand, however, we would only, apart from noticing and recording the stand of WhatsApp also, that they have given the undertaking which is contained in the paragraph of the letter which we have extracted. But and also that we should issue appropriate directions for causing wide publicity to the set stand of WhatsApp for the benefit of those consumers who may not have agreed to the terms of the privacy policy, etc. of 2021. Accordingly, the application is disposed of as follows, paragraph. What we record the stand taken in the letter dated so and so 22nd May 2021, and we also record the submission of the London Senior Council for WhatsApp that they will abide by the terms of the letter which we have extracted. Till what? Till the further
also. Yes, no, but it says till GDP comes. That's the obligation.
So that there we will extend it. Until till at least the next date of hearing.
Your Lordship is putting 10th April. Can be up to 10th April.
Yeah, we'll till the next date of hearing, so that we can extend.
But if the bill comes
before the bill comes,
see, no, 10th April.
Then you have to. Otherwise, it doesn't serve the purpose. Till the next date of hearing.
I think that's correct.
Till the next date of hearing.
That's correct.
That's, I think it's. We further direct that. WhatsApp will cause publicity to this aspect for the benefit of the consumers of WhatsApp, customers of WhatsApp.
By giving the same advertisement
in how many?
By giving the same advertisement as we gave in January, which is on the record.
By giving what newspapers? National newspapers.
National, yes. Five national newspapers, your Lordship may say.
Five
national newspapers.
By
giving the same advertisement
on 2 occasions.
All right, all right. By giving the same advertisement as
what is it? Quarter pages.
Quarter page.
Advertisement shall be, if you want, make it full page.
No. It's very expensive.
Full page,
What a
full page is for others.
Full page not necessary.
But it should be fairly. It should be.
Yes,
the quarter page is so much.
Quarter page is a lot, Mullah. Nowadays, people look at quarter pages.
That first page on the right big.
Newspaper, I got some ad in the front. They got some building ad.
On the front page.
They call it Solace.
So that we put it on the front page. Eh?
Yes, we put it on the front.
They may not be quarter page on the front page. We have practical problems are there.
What is the problem?
The front page normally will carry a full ad of a building, car, etc.
I'll tell you something. So gone are the days when you try to go to the news.
We can give full page.
Today we have to wait.
Same full page we will give.
Well, we'll give full page, the same full page as we gave in January.
Easy.
It's easy,
Because quarter will not be.
Nobody will.
Yes, it's the quarter red, Malad. What's the point?
They have no objection.
No, we'll give full page. No issue.
Same advertisement, full page.
Full page on 2 occasions.
Yes.
On 2 occasions.
Which is the same which was given in January.
Which was already given in January of 2022.
In terms of what was already given on what day?
January 2021.
2021.
Correct. 21st January 2021.
Yes.
21.
Yes.
Was it
21?
May 21 letter.
May 21 letter.
This is a May 21 letter.
It is not about the letter, it's the advertisement.
Different.
No,
but same thing.
What the same thing. Was reproduced is subsequent to the January letter.
So you
further
in terms of, it's the same thing. What he's saying.
It's the same thing. We'll put it, Malad. Leave it to us.
The same undertaking will be in the whole page. That's why
That's all.
It's all. Whole page and.
Is this that page 171 of the application?
Yes, and it does not mention that you will not be forced to accept. That was pre this undertaking of May 20.
Yeah, but we'll include it. We'll include it.
May undertaking.
We'll include it. It has to be there.
If your Lordship can simply say.
Advertisement will necessarily incorporate the stand which has been taken.
Yes, in the letter.
In the letter dated 22nd May
Correct.
2021.
Correct.
That's
Fair
very,
enough.
very clear.
Fair enough.
Correct. Nothing
else.
This is case for direction.
So that a restricted portion of it will be there.
IA will stand this that we have already said. IA will stand this for direction. I've said that day.
11. Main case to be listed for direction.
11th April.
Not IA, main case.
IA is not.
Your decision.
The
11th April.
11th of April.
Yes.
This is 11th of April, 10:30. What direction?
Your Lordship only said this is without prejudice because that para itself says that they can display those notifications again and again.
What is all this?
So let it
We
be
can.
without prejudice to our
You can say needless.
He is not even filed IAR.
Needless to say, this will be without prejudice to the contention of all the parties.
Only, your Lordship said about visual media also.
No.
Doordarshan.
Yes,
No, Manoj, please don't. Manoj, this will be enough. There's no need for Doordarshan. Manoj, this is.
Why are you?
Manoj, because people, Manoj, the visual media is good if you keep on, Manoj, keep on advertising again and again and every day. How will you put an ad, Manoj, on the news in the media?
The person read the text.
Central government can publicize it in.
But how do they read the text in a visual media?
The mode of public.
There can be a voiceover.
How do you read the text on a television channel? I don't understand. It makes no. It's not a practical.
Every user get an information.
Yeah.
Every user is getting an information.
By now it's all through.
Manoj, can I suggest one thing? Can I say there's a ticker which comes down? You can simply say that. No. We start putting advertisement. Who's going to read it? Exactly.
What he's saying is right because the sticker.
The ticker will come. WhatsApp will not opt out.
No ticker, for God's sake, no ticker.
No, you don't ticker.
If you are actually showing this on the screen of a TV,
Supreme Court.
to read this one full page, how much time it should be? It should remain there.
A couple
Minimum.
1 minute.
1 to 2 minutes.
Nobody will accept.
Nobody will accept it, Manoj. Nobody accepts such an ad.
Voiceover.
It's a big pragmatic. Big pragmatic.
Yeah.
Newspaper is sufficient.
That's right. That's what
Deeply
I
obliged.
Manoj, I just want to mention, Manoj, it was no intention of us not to go on with the matter. We just had some practical difficulties. We know how much time it would take, Manoj.
It's always nice to end with a humorous.
You have put in your practical. You have put in your practical
To play a person who lacks humor altogether.
You have put in your practical difficulties. You have put in your practical difficulties. We have put in our practical difficulties.
I appreciate that.
Very grateful.